Hi, folks. How are you?
Good.
Very
Good.
good. Everybody can hear me okay? All right. Well, we'll just go ahead and get started if that works for everybody. Um, I'm Matthew Winton. We're recording this so that others can watch at a later date. I usually will post this on my blog. I know Neighborhood Alliance, I think, posts slides and possibly a link to the video. So if you missed something, it should be up on our YouTube channel within a few days. If you've never attended one of these, whether back before COVID days we were doing these live, since then we've just done them via Zoom. These are 2-hour conversations starting tonight and then in a couple of days. So we we used to call this the first part basic and then the second one advanced. We've moved away from that. It's just part one, part two. So in part one, what I do is try to cover some terminology. And tonight we're going to immediately jump into some slides or stacks, I think, as my children call them now. We don't call them slides anymore. Their topic of leasing restrictions. That's probably the hottest, most requested topic that we're getting, whether it's transactional work or litigation, is leasing restrictions. And that runs the gamut from short-term leasing, long-term leasing, and we'll go over some of the differences and the ins and outs. But I'm going to share my screen and start going through these slides. If there's a comment, question, we kind of take those as they come, and don't be concerned if I don't get to it right away. I will look periodically, and my friends at Neighborhood Alliance are good to remind me to, hey, we've got a question pending, and we'll get to it. But sometimes I won't answer the question immediately because I know we're going to get there. All right. So don't be concerned if I don't immediately hop on it. Okay. I'm going to share my screen here. And actually, I'm just going to leave it like this because I think if I do full screen, I won't be able to. No, I can still see if a comment comes up. Okay, so I'm going to breeze through some of these introductory slides. If you've never been on this before, this is education. This is not legal advice. I don't represent any individual. Don't represent your association as for purposes of this conversation. I may and probably do represent a number of your associations that you serve on a board, and that's fantastic. But what I'm not providing tonight is legal advice. Okay, I will do my best to answer your questions, but the the old adage is that the facts make the case, and that's very true when it comes to the topic of covenant enforcement. One of the questions is, well, what teeth do our covenants have? Well, it depends on what your covenants say. If I haven't read them, I certainly can't give you an opinion, and I can't answer what kind of teeth they have. But we will talk about the various forms of teeth that are available out there for covenants. So I'll try to answer it that way. Okay, we have a number of resources out there. If you Google my firm, you'll find I have a blog that I've been writing since 2003. You'll find a lot of these videos on YouTube, and you'll find our website. I also wrote a handbook several years ago that's available. All right, let's talk about the substance of HOA law and issues. And I want to start off with this slide because I say these in HOA meetings, and I go to a lot of HOA meetings, whether it's transition from a developer to the resident owners, getting a board elected. I'm going to an HOA meeting for a neighborhood in Oklahoma City tomorrow night just because they have a high turnover for their neighborhood and they like to have the manager and the attorney come out and just go over the basics of what it's like to live in an HOA. And I've gotten into the habit of commenting or going over what the purpose of an HOA is. A lot of times people think that the purpose of an HOA is to tell people what you can and can't do with your what you can and can't do with your property. And at some level, at some point, maybe your association will tell someone what they can and can't do with their property. But that's not the primary purpose of an association. In my world, in my view, the primary purpose of an HOA, and when I say HOA, I'm talking about homeowners association, condo association, property owners association. I don't care what you call it. It's kind of the same general concept. It's a, a bundle of rights, responsibilities, mandatory membership tied around uh, some typical real property element, whether it's a drainage area, private road, or just people's lots. So anyway, the purpose in my world of an HOA is to promote community. And the ways associations typically will promote community is by providing information, education, and some kind of customer service, maybe even a product like information packet, uh, social media platforms, things like that. In addition to the services of providing common area maintenance. A lot of times, well, not a lot of times, but by ordinance in a municipality such as Oklahoma City, Edmond, Norman, Mustang, Yukon, Tulsa, Broken Arrow, all of these major metropolitan towns, cities, if you're going to have drainage areas, which most developments these days will have to have some kind of drainage element, then the city is going to require an association to be created. Okay. So one of the, well, why even have an association at all questions, and that's one that comes up. That might be one that comes up is how do we get rid of our association? And we can talk about that a little bit later. But answering the why do we even have an association in the first place, oftentimes it's because a municipality is going to require the developer to have that kind of private common area maintenance entity in place. All right. Some of the other things that your association should provide is leadership and governance. Now, governance could include things like telling people what they can and can't do with their property, but that's kind of built into some of the systems because if your covenants provide for mandatory membership in an HOA, well then the question becomes, well, how does the HOA operate? And typically it's through an elected board. So that's leadership and governance because the board is going to be vested with the discretion, the business judgment to decide how they want to manage the common areas and what kind of information to provide, and then what kind of enforcement techniques if the covenants have thou shalt do this or thou shalt not do that provisions. Okay, that would be under the governance. And something that we'll talk about later too is associations. If there is a management, or excuse me, a mandatory component, meaning you have to be a member if you buy property within the neighborhood, then oftentimes, but not necessarily so, the covenants will provide that the association can enforce the covenants. But long before the idea of putting a mandatory association in on every neighborhood was the law that individual lot owners, if they're subject to covenants, they can enforce the covenants. Okay. There's this idea that, well, association, my neighbor is doing something that violates the covenants, therefore you have to do something about it. And that simply isn't true, and that's not the law. You can request that the association do something, but the board in its business judgment or its discretion could say, yep, we agree with you, but we're just not going to pull the trigger on that. And maybe we can get to it. We can look at it next year. that doesn't stop the conversation. The aggrieved lot owner could move forward, but what the lot owner can't do is force the association to fight its battle for them. Okay. All right. So that's a general overview of what associations do, why they're created, and then we kind of dipped our toe into some of the uh, deeper slides that we'll talk about later. All right. So in terms of, I'm going to use the phrase governing documents or CCRs probably throughout these 4 hours that we're going to spend together tonight and in a couple of days. When I talk about governing documents, what I'm talking about are the various contracts. The law says covenants are in the nature of contracts. They're not necessarily exactly like a contract because there's not this bargaining back and forth. Sometimes they're referred to as contracts of adhesion, meaning it's a take it or leave it. You either buy the property and it comes subject with whatever covenants, or you leave it, you go buy somewhere else, go buy your patch in the country that doesn't have any covenants. But covenants are the documents that are filed with the county clerk's office, sometimes called declaration of covenants, conditions, or restrictions, sometimes referred to in short form as CCRs. It doesn't matter if it's called an owner certificate, deed of dedication, doesn't matter if it's attached to the plat. So if you're in Tulsa, if you go flip through the pages of the plat, and pretty soon you'll get to what's titled a deed of dedication, and that'll be a set of covenants. Tulsa County and surrounding counties do it a little bit differently than Oklahoma County and its surrounding counties with that deed of dedication. You don't find that in the western part of the state, but it's something to look for on the eastern side. The plat is a legal description of the neighborhood, and for each neighborhood, it could have multiple plats. It could just have one plat. And I'm going to show you a picture of a plat here. This is a neighborhood in Edmond, Oklahoma. And it may be difficult to see, but if you look at it, it shows lots by number and block. And then it shows common area by the words common area, and then it has letters. And that's a very common thing to do. Lots are numbered, common area is lettered. And the plat is a really interesting document because it's going to answer a number of questions. First, what are the lots? What are their what's their layout? How many are there? Are there easements? Are there setbacks? All of this kind of stuff is going to appear on the plat. Now, there could be off-plat easements, possibly even off-plat setbacks, but most of the time we're going to find that information on the plat. It's also going to answer the question whether we have public or private roads. So if that's one of your questions, the first place to look isn't the covenants, it's not the declaration, it is the plat. And the plat will answer other questions like, I don't know if you can see my cursor or see this area right here, but it's hard to read, but it says notes, and every plat is going to have a notes section, and it might have some really good information, such as, does the association maintain the sidewalks in the neighborhood? Does the association maintain the islands in the public roads or the entranceways? So it'll provide us some really good information. And some of the other documents that we're going to look for when we're piecing together a governing documents file, we're going to look for articles of incorporation. We're going to look for bylaws. And oftentimes you can get these from your seller if you're buying property, the prior board, the developer, a realtor, but there's not a centralized location for all of these documents. Okay, so we would have to go look in various locations if somebody didn't just hand us a governing documents file. So where do we find these documents? Well, the plat and the declaration or the covenants, owner certificate, all of that's going to be recorded in the county clerk's office. So whatever county your property sits in, go to that county's office or go to that county's website, more likely today, and you can download or get electronic copies of the plat and the covenants. So plat, covenants, anything dealing with the real estate must be recorded in the county clerk's office, right? And then certificate of incorporation, articles of incorporation, those you're going to find at the Secretary of State's office. You can either go to that office and get copies, or they have a really good website and online service where you can order those. Now, bylaws. This is where we need to make a distinction in the world of HOAs versus condominiums. So condominiums are not a type of structure, although most people think they look like apartments or townhomes or something. Condominium refers to a form of ownership. And that form of ownership lends itself to developing structures that look like apartments or buildings, sometimes townhomes, duplexes. It makes selling property that has shared walls or really close living very easy, as opposed to having to get legal descriptions and sell them like homeowner association type lots. So anyway, the world in real estate is divided, at least for the purposes of this conversation, between homeowner association, which are platted lot type developments, and condominiums. So the reason I'm making that distinction now is because for condominium developments and associations, the bylaws have to be recorded at the county clerk's office. Under Oklahoma law, you cannot create a condo without filing bylaws of record. That's Oklahoma statute requires that. Okay. So if we're dealing with a condo, we can go to the real property records, and usually they will be attached as an exhibit to the declaration creating the condo, but not necessarily so. Could be separate, but most time it's an exhibit. When I do development work for platted lot communities, I always file a copy of the bylaws as an exhibit to the declaration so that there's no question it applies to the property and everyone can find it because it's a matter of public record. But you don't have to do that for an HOA. So it's possible to have a mandatory association. You have the covenants filed at the county clerk's office, and you can't find a set of bylaws to save your life. Well, it doesn't mean the association doesn't exist. It doesn't mean you can now ignore it. Nobody has to pay dues. It just means you have either an incorporated or possibly unincorporated association that doesn't yet have a set of bylaws. They can be adopted at any time. So it's not the end of the world if you don't have bylaws, but I would put it on the to-do list right after. If you find that your association is not incorporated, that is the very first thing to do tomorrow when you wake up, is to go get your association incorporated, because no one wants to operate or be a mandatory member of an unincorporated association. The reason is because each of the members in an unincorporated association have joint and several liability. It means you're all equally responsible for whatever bad might happen. Now, most of the time, bad things don't happen in HOAs, but if they do, the time to find out isn't when you don't have insurance and when you don't have a corporate charter protecting you. All right. So I'm going to talk fairly quickly about the development process, and because sometimes it's helpful to know how these developments come together. And so very quickly, just in terms of staging and how this goes, developer finds a piece of property, or if it's a condominium development, developer finds, or a group of investors find a building. Back in the 80s, FDIC took over a lot of projects because banks went under, and they were left with these apartment complexes. And a lot of those apartment complexes were converted to condominiums. It's a fairly common conversion thing. Well, whether it's real estate or whether it's a condo conversion, Oftentimes there's some kind of zoning that needs to be done. Oftentimes we will incorporate the association before we even plat or file covenants, just going back to my prior comments, just because it is so important to have a corporate protection for our HOA members. So then we might file a plat if it's going to be platted, and covenants immediately after filing the plat. One of the questions that sometimes I'm asked to provide is my property, or are the properties subject to covenants? And usually that's very easy to answer. We'll have a plat that's filed, say, on day one, and then on day two, or even later on day one, we have a set of covenants that are filed. If that's what I see, well, then yes, all of those platted lots are subject to those covenants. Where we have a problem is where plat is filed on day one, you find a handful of deeds to builder entity from the developer on day two. You see maybe a mortgage and then maybe something else, and then you find the covenants on day 10. Well, now I have a gap between the original developer owning the property and all of the lots, and that is who has the right at that point to execute covenants. Anyone else who has an interest in the property, they also now must agree to those covenants. So if lots get sold to a developer, or excuse me, to a builder from the developer, and the covenants haven't been filed yet, well, now we have a gap, and we need to fix that. So the important purpose of getting the covenants filed is a state statute dealing with constructive notice. And what constructive notice means is, even if you had zero awareness that there were covenants filed against the property, if they are filed, well, you're going to have to follow them. You're going to have to be subject to them. It's kind of the statutory version of ignorance of the law is no excuse. So if I'm speeding, but I don't know what the speed limit is, I don't get an out from the ticket by saying, well, officer, I didn't know what the speed limit was. I am that knowledge is imputed to me, and I am held to that assumption that I should know, or that I do actually know. Okay. So then once the original setup is completed, whether it's plat, condominium, then all the lots are sold, they're constructed. And at some point, the developer is going to want to transition control of the association and transition control of the design process to the resident owners. There is nothing in Oklahoma law that says when a developer must do that. Okay. So, and very few sets of covenants will actually spell out when the developer has to hand it over. We'll talk about Class A, Class B membership in a little while, and parse out maybe some of this timing a little bit more. But at some point, the idea is developer gets rid of all of their property, and what is left is the ongoing, continuing forever, in perpetuity, the operation of the association and the resident owner control of the association, and like I said, the design review process. Around that time, not necessarily before, not necessarily right at, but definitely sometime,
I got it.
there's going to be a transfer of there's going to be a transfer of the common area to the association, to the corporate entity association. And that's typically a deed. Now, one of the questions, issues sometimes that comes up is, well, the developer hasn't transferred. I'm going to ask everybody, if you would put yourself on mute. That way we don't have background noise. Thank you all. So one of the questions that comes up is, well, developer hasn't transitioned hasn't transferred title of the common area to the association yet. Well, if the developer is in the middle of constructing drainage improvements that allows everyone to get their certificates of occupancy, well, fine, no problem. That's part of the development process. If they're in the middle of constructing a clubhouse, swimming pool, even if they've been promising it for years and years, well, fine. It's in the middle of the construction process. Now, maybe you're right that they've waited too long, or it should have been available earlier. But developer is vested with a lot of discretion on how to spend their money, just like families are vested with discretion on spending their money. Developer doesn't necessarily have to spend it on our timetable. So, but at some point, the idea is the association owns the common area, and then we have this continued operation. All right. So, um, some of the things that we look for in the declaration, and this is by no means exhaustive. These are just some of the high points that I want to hit, and that I feel like we can hit in the limited amount of time that we have together. But one of the things that we look for in covenants is a definition section. So in contracts, if you come across a word that is not a proper noun and it's capitalized, either someone is just going crazy with capitalization, which is entirely possible, or they're following a very old, very tried and true contract drafting technique, and that's using defined terms. So something that I look for in covenants, and that this is a real common drafting mistake, is you're reading through your covenants and it says the property, and then it talks about the addition, and then it talks about the neighborhood, and then it talks about the project, and they're all lowercase, and you have no idea whether all of these words mean the exact same thing. Are they just synonyms for the development? Well, we don't have to scratch our heads. We don't have to create ambiguities in our contracts or in our covenant drafting. We can use defined terms. And then the important thing is using those defined terms consistently. So if we defined the entire development as the property, capital P, well, then we can't introduce the neighborhood or the project or the addition later on. We need to stick with our defined terms. There's also this drafting thing out there where it's like, well, maybe they didn't get the idea in the declaration, so we're just going to repeat everything in the bylaws. There's no reason to do that. So bylaws um, should stick with the business of the corporate entity. Now, there is going to be some overlap, but bylaws don't need to have extensive provisions on assessments and special assessments. Bylaws should have some enforcement language. Bylaws is typically where we will find the due process clause or procedure. So we'll have some enforcement overlap, but what we don't want is extensive duplication or mirroring of language in the bylaws, primarily because what happens is the language changes by the time we get to the bylaws, and now we have a conflict. Oftentimes, in a good set of bylaws, it will have what's called a conflicts clause, and it'll say something like, in the event of a conflict between the declaration and the bylaws, then then the declaration shall control. Typically, we'll have the declaration controlling. But if we have a conflict, we don't have a conflicts clause, well, now we have an ambiguity and we got to figure out what to do with it. Something else to look for is you might have multiple sets of covenants for the same neighborhood, and that might look a little different depending on who the developer is. So in a phase development, and what I mean by phase development, you have section 1 is platted and filed, and covenants are filed for that. The association set up. You have the complete governing documents package set for that development. And then the developer files a second plat and adds more lots to it. Well, the covenants for the first plat should have given you notice that this is a possibility. It may have language about annexation or addition. It may have some kind of procedure where the developer must get a certain percentage of lot owners' permission or vote of approval to add additional lots. Um, you never know until you read the covenants and see what they provide. But that's called a phase development, and oftentimes in planned unit developments, PUD, if you're familiar with that, that's the idea. Is we have this big chunk of land, we want to put so many houses on it, and the municipality or the zoning authority says, okay, we'll let you do that as long we'll let you bulk up over here if it's green, green space up here, or this is the drainage plan. So that's one of the benefits of a planned unit development is you can tinker with some of that massing or lot size, and and usually they're built in phases. Well, when that second phase comes along, some developers will file a completely uh, similar, substantially similar, almost verbatim set of covenants as they did in the first section. You can do that. There's a number of developments that's exactly what they do. There's a better way of doing it, and that's filing what's called a supplemental declaration. And instead of filing a whole new set of covenants, you file basically a ditto document that says, hey, world, remember the covenants that we filed for the first section of this development? Well, we're now adopting those for this second section, just like the plan was all along. So that's typically called a supplemental declaration. And it cuts down on the paper. It also cuts down on the likelihood that there's going to be substantial changes uh, between the first set of covenants and the second. Sometimes it's problematic where if you had one developer for phase one or section one, then you had a new developer for phase two, section two. Sometimes the different developers have different lawyers, they have different pet language that they want in their covenants, different basic forms, and it can create some significant issues on, okay, well, now we have one association subject to two different types of procedures for, say, due process or board elections or something like that. So it can create some issues. One of the things that you're going to find in a well-drafted set of covenants is this idea of declarant, oftentimes class B. And if you read through, again, well-drafted covenants, some that developers thought about, the declarant is going to pretty much control everything until they decide or they sell out their last lot. They're going to control the association board, and they're going to control the design review board or architectural review committee or building committee, whatever you call it, whatever it's called in the covenants. Typically, the declarant will control that. Now, one thing to look for is do the covenants tie control of the association to control of the DRB or the ARC? When we draft them, we do not, because there will come a time, often in most developments, where my developer client doesn't want to control the association anymore at a certain point. And sometimes people will say, well, at 50% or at 75%, the developer has to turn it over. That's not accurate in Oklahoma. There is no law that says 75%. There are states that have adopted laws that require it at 75%, but not Oklahoma. So at some point, though, not necessarily 75, it could be 95, 100, but at some point, the developer wants to have the resident owners in control of the association. And if things are going really well, it's around that time that the resident owners are thinking, hey, we should probably be talking about us controlling the association. Now, the reason why the association might get transitioned to resident owners and not design review is, for the example, if a developer, say, sells all of their lots, sells 20 lots out of 100 to a builder, the builder might be sitting on those for a while. The developer, and actually it may be part of the sales agreement between the developer and the builder, that the design review stay with the declarant, because the builder wants to deal with the person they bought the lots from and the person who envisioned how the design and architecture would be in the neighborhood. They don't want to deal with resident owners who may have a different plan and make their building process difficult. Not necessarily that those don't necessarily go hand in hand, but it's very common where the initial house construction or lot build out, that design review process is going to remain with the developer. All right. And then the other question on this slide is what retained declarant rights? Well, what do we mean by retained declarant rights? Well, in my mind, there's two primary declarant rights that we want to make sure, at least when the developer is my client, that we want to make sure they have. And that's what annexation and addition rights will there be or are there? And that's a retained developer right. We don't want individuals, we don't want builders being able to decide, you know what, we're going to add to this neighborhood. And we only want the original creator, the developer, to be able to do that. And then second, typically we will have a retained developer declarant right to unilaterally amend the covenants. Now, you can imagine what happens when a developer goes in and uses this pretty substantial right to completely change things or change the deal. People go crazy, and rightfully so, because even though they've retained that right, these are their customers, and there's not necessarily an implied bargain, but if you try to use these retained rights to dramatically, say for example, you build 75 homes out of 100 platted lots to a 2,000 square foot minimum, and then you come in and you decide, you know what, I'm going to build 1,000 square foot. People are going to go nuts, rightfully so, and probably challenge that. And there's going to be a question of whether that's reasonable. And a court could strike it down if it's not reasonable. So usually these retained developer rights are used with caution, and oftentimes are a really great way, once the developer's transitioning out, the lot owners can use the developer right and convince the developer, declarant, hey, look, can we make some tweaks to these covenants before you exit the building? And oftentimes you see declarants working with their customers or lot owners to help facilitate those requests. So sometimes it works really, really well. Okay, let's talk about, there we go. Let's talk about where to find the law in Oklahoma. There's not a whole lot, and I'm not going to spend a whole lot of time going into detail on the law unless somebody has a question about it. But in Oklahoma, as in other states, what the law is one, it's statutes, which are bills that have been introduced, that have gone through the process, that actually make it to the governor's desk to be signed into law. Or they are cases that have gone through the court system and have been what's called reported. Not that people know about it, not that there was a newspaper article, but if a case has gone to the appellate courts in Oklahoma and is a Oklahoma Supreme Court case, or a case that the appellate court has agreed from the Court of Civil Appeals to be published, well, then those can be cited as the law in Oklahoma. So there's a handful of HOA cases, a handful of condo cases out there. Our HOA and condo law have been around for many years, have not been substantially updated or amended. The Condo Act has never been amended since it was adopted in the late 60s, which is pitiful, but it is what we have. And until the legislature does something about it. It's what we have to work with. So I have given you the address for these statutes. I also mentioned Title 18. There's some great language. So where our legislature has maybe not gotten it, done it really well with the real property side, our legislature has adopted some really good statutes to protect HOA board members and all corporate boards alike. And we have some really good functional law. Thank you, Delaware, for providing us the model. And so if you find that your association is incorporated but doesn't have bylaws, we have some really good default rules, unless otherwise provided language, meaning unless you have articles that speak to this, or unless you have bylaws that speak to this, then we're going to supply you a quorum. So it's pretty good functional language. If you don't know about oscn.net, familiarize yourself with it. It's where you can find all of your neighbors' speeding tickets, their divorces, their criminal convictions, and you can also find all of the law that I just referenced, and it's for free. So really good resource. Okay, let's talk about leasing restrictions. And I'll just kind of jump off into this hot topic. All right, our firm has been litigating leasing restrictions. This is probably the #1 amendment that associations ask for, that want some kind of leasing restriction that wasn't already built into their covenants. A few years ago, prior to COVID, leasing restrictions were not that common. And I'd get asked for a leasing restriction amendment every now and then, but definitely not as frequently as now. You would see them in condominium governing documents much more frequently than single family. And so what a leasing restriction is exactly what the name implies. It's some type of limitation, or call it brake pedaling for leasing. I won't go into great detail on some of the theories out there. There is anecdotal, not evidence, but there's this idea out there that people who lease property don't take care of it as well as people that own it. That is definitely debatable. It's certainly not reflected in mortgage company underwriting requirements, because a certain amount of leasing is not only allowed but required under certain lending programs. So the idea that we should or even could prohibit all leasing in a neighborhood, it's not realistic, it's not reasonable. And even though we don't have a statute or a case in Oklahoma on banning all leasing, it's not a great idea. And there's much better ways to attain what is typically a not an issue of whether someone owns property or leases it, but it's how is a person using their property. Because you can certainly have an owner who doesn't take care of their lawn, and you can have a tenant whose landlord pays to have the lawn mowed every week, or the tenant mows it themselves. So just the fact of ownership versus leasing occupancy may not be the focus that we need to be addressing. If there is going to be a leasing restriction of any kind, it has to be in the Declaration of Covenants. It has to be in a recorded covenant. It's possible it can be in bylaws if the bylaws are for a condo association. You cannot, and if a lawyer tells you that you can adopt a rule or the board can adopt a bylaw to restrict leasing in your neighborhood, you need to find another opinion. or make sure that lawyer has plenty of insurance. You cannot restrict one of the fundamental bundle of rights that comes with property ownership, and that's leasing, simply by board action. Okay. So if there's going to be a leasing restriction, we're going to find it in a recorded covenant. Again, if bylaws, it's going to be in the recorded declaration of covenants or the bylaws. So that's why I've got these highlighted. I'm going to go to the chat real quick. And let's, oh, sorry, DRB, Mark, you got it. Design Review Board. That's right. So DRB is just a short form for Design Review Board. And whether we call it a DRB, ARC, AC, whatever it is, it's this group, typically 3 people. Sometimes they're the same 3 people that are on the board, but not necessarily so, that are given authority. And this is important. These people, if they're acting as the Design Review Committee or Design Review Board, ARC, the covenants have to give them authority. They can't just make it up. So the fact that you have a homeowners association doesn't necessarily mean there's someone out there that can tell you what kind of shutters to put up or whether your roof can be this color or that shingle. So all of this has to be spelled out in the covenants, including the fact that there is a design review board or ARC and what the scope of their authority is. Okay. All right. We are going to talk a little bit more about these leasing restrictions. So I'm going to depart from my slides a little bit and just kind of talk about the gamut of leasing restrictions. So let's start with short-term rentals, because in fact, I had a conversation with an individual today, and he had received a demand letter about his home being used for an event center, party house, short-term rental, Airbnb kind of thing. And his question was, well, what's the difference between what makes a short-term rental? And the idea is, well, what's the difference between short-term rental and long-term rental? What's the time frame? Well, there is no time frame. It's not short-term rental doesn't necessarily refer to a span of time. It refers to a type of use. And so it's possible that if the issue that your neighborhood is having is short-term rentals, party houses, vacation houses, event centers, whatever you call it, the short-term rental could be one night, it could be 60 nights, but the use is different. It's the use that is substantially similar to a bed and breakfast, an Airbnb, where you're provided cleaning services, towels, things like a hotel motel would provide. What you don't see is a lease agreement. Typically, you don't see the individual using the house, putting the utilities in their name. You don't see them mowing the yard or having the liberty to put up artwork, or they don't bring furniture with them. It's typically furnished. I've never stayed in an unfurnished Airbnb. So the substantial differences between short-term rental and long-term rental are the fact that one uses the house like a product, or the landlord or the owner of the house uses the house like a product, as opposed to using the house as a resident occupant house. So even though money exchanges hands with both, there's a significant reason why Oklahoma City and various other municipalities that are adopting Airbnb ordinances, they don't have the same requirements for long-term residential use of property. And so landlords with tenants don't have to pay hotel motel taxes. They don't have to get a business license or register, like the short-term rental, hotel, motel type uses. So that's pretty much the basics on short-term leasing. Now, on long-term leasing, um, one of the easiest, most straightforward to administer leasing restrictions is not really a leasing restriction at all. It's an initial owner occupancy requirement. And so what that does is um, instead of saying, well, we're only going to allow so many units or so many houses or lots to be leased at any given time, what an initial owner occupancy requirement does is says for the first 12 months, or sometimes you'll see 18 months, but for an initial term, the property must be owner occupied. Now, that initial term is every time that property sells. So new property comes on the market, it's sold to an individual. That individual must own that property and occupy it. We'll talk about occupancy in just a second, for whatever that term is, typically 12 months. They cannot put a tenant in that property within that initial time period without violating that covenant. So what does this do? It keeps institutional hedge fund type investment companies from coming in and buying a bunch of units in your neighborhood and then putting tenants in them. Now, it does allow leasing in your neighborhood, but who is going to be doing the leasing? It's going to be someone who's at least occupied the property for the initial term, your neighbor. Now, maybe they couldn't care less about you or the idea of being a neighbor, and they just gritted it out for 12 months in order to put a tenant in there. Those people are very few and far between. In fact, no one buys property to sit on it for 12 months and just so that they can have a leasing unit. There's much more opportune markets and houses out there to purchase rather than suffering through a 12-month restriction. Something that we also do with, and back to the occupancy, you cannot force someone to occupy property. So if individual wanted to buy the property and let it sit empty, you could do that. There's nothing that says somebody has to sleep so many nights in a particular house. You couldn't enforce that. Besides, this might be their second home. This might be their I'm going to attend the OU or OSU game weekend house. That's perfectly fine. As long as they don't have a tenant, long term or short term, in there, then that's fine. Something that we'll also do is we'll expand the definition of owner so that we cover those situations where, say, me and my spouse live in a property, we're aging, one of us needs nursing care, then the other one needs nursing care, and in order to pay for two nurses, two nursing care, we need a tenant or we need someone to occupy the property, but we don't want a stranger. We don't need to be a landlord. We don't want the headache. And so we want my daughter or, um, a niece or someone to move in. So a lot of times what we'll do is we will define owner occupant as within, say, 2 degrees of consanguinity, and that'll include grandchildren, nieces, second cousins, things like that. So what we're looking for is to, as best we can, preserve that family type use of residential property, and but not be so limited that we exclude certain situations that we wouldn't want to otherwise. And then with the initial owner occupancy, once you meet that initial term, you're free to lease the property as long as you want. And that's where some people are like, well, no, we need to restrict leasing. But the thing is, with the condition that it be initial owner occupancy for 12 months, 18, whatever, the percentage of people who actually turn around and will lease that property during their ownership is exceedingly small. In fact, it's often much smaller than what most leasing restrictions will provide, and that's 10%. So usually around 3-5% is what you'll find. So it's a pretty functional leasing restriction. On my prior slide, I had things like, well, what about approval or background checks? We don't have time to go into it, but there are very good reasons why you do not want board of directors in the business of doing background checks and deciding, well, let's let this person in, let's not let that person in. That is a Fair Housing Act violation, or at least complaint waiting to happen. Something that I have highlighted on here that's going to be a big deal, and if your covenants don't address it, you might just get it on your radar and think about it, and that's ancillary building leasing. So sometimes these are called ADUs, ancillary dwelling units. In other states, this is a big deal, has been a hot topic for a long time. It's just now getting going. Well, that's not fair. It has been a conversation, at least in Oklahoma City, for a year or two. And some people are really for it, some people are really against it. But basically, what it means is you build a tiny house and you allow someone to live in this accessory dwelling unit on your property. What does that look like? What does that do to parking? All of that stuff. Those are things to be considered. Something else that you can do in your covenants is limit the number of unrelated occupants. So in college towns like Norman, you'll see ordinances, zoning ordinances that prohibit, so many unrelated occupants from living in the same dwelling. You can also do that in your covenants. So we are about at the 1 hour, and I'm going to skip through several slides. They'll be available, like I said, online. These deal with specific city ordinances. Oklahoma City short-term leasing. Oklahoma City has a short-term leasing ordinance. You can look at that. Oklahoma City also has a chickens and quail ordinance, and I put both of these just so that you're aware of them, but also each of these ordinances, and this is very common, each of these ordinances provide for the enforcement of covenants, or at least give you notice that, hey, look, just because you get a chicken permit, just because you get a short-term leasing permit, business license in Oklahoma City, doesn't mean you're good with the covenants. The covenants can still be enforced. So it's just like you could have a public street and have covenants that prohibit certain things to be done or not be done on that public street, like parking, like leaving trash cans out. So there is this layering effect. Now, covenants can't allow what ordinance prohibits. So if say for example, well, with this chicken ordinance, if it only allows 6 hens and no roosters, you couldn't have a set of kind of covenants that says no hens, all roosters, and you can have 12 of them. That cannot be done with covenants, but it can go the other way, where the federal, state, or local entities have allowed something, then covenants can, by agreement, be more restrictive. All right, there's a couple of comments. Okay, so one, what are the pros and cons of filing bylaws with the county clerk in addition to the covenants? Um, I don't find any cons to it. I guess if you twisted my arm and said, well, you have to name one bad thing about filing bylaws, it's that, okay, if you're going to amend in the future, then you should remember to file that amendment as well. Otherwise, people will think that the original bylaws are the only the current version. Not really a con, because if your original bylaws are filed, you're probably going to be aware of filing an amendment too. The upside to filing bylaws goes back to constructive notice. And I find a lot of associations that are operating on an unsigned, unfiled set of bylaws. Well, when I come across that, my first question is, well, how do you know these are even real? What are you relying on that says these bylaws were ever adopted? And usually it's, I don't know. So in that case, what we'll do is we'll adopt those bylaws and then we'll file them, or maybe not file them, but um, there's just really not a downside to filing the bylaws. And if you find yourself in a neighborhood where covenants were filed and you don't have any bylaws and you're debating, well, should we file this? Should we not? Um, and you ask my opinion, I would probably say, let's go ahead and get them filed. And that way we have it of record. You've got that official stamp. Anybody can find them. Realtors who are selling property in your neighborhood can go to the county clerk's office and find them. So um, I don't think that's a bad thing. Thank you for mentioning that moratorium. So yeah, so what used to be handed out like candy, including exemptions from the county for what the ordinance says is operating a business. Now cities, and it's not just Oklahoma City, Taos, a lot of cities, New York City, they're finding that, okay, Airbnb, short-term rental, hotel, motel type use can be great. However, it is possible to have too much of a great thing. And so where you had this crush of everyone using their property for Airbnb, and it was fine, people wanted to get away, but now we are finding a lot of party houses, event centers, these houses being advertised for birthday parties. And so look, having your kid's birthday party at your house is perfectly fine. That's I don't even think that's a business use if you charge the parents admission. But having that as a money-making enterprise, that's the problem. That's the difference between a short-term rental and long-term rental. It's you are now using that house not as a resident occupant use. You're treating the house as a product, and you're selling that product over and over and over again at the use and enjoyment expense of your neighborhood, of your neighbors in your neighborhood. That's the problem, and that's why we're seeing um, these cities taking a step back and saying, well, hold on a second, maybe we need to modify this a little bit. One of the questions, can the board amend the bylaws without a vote of the HOA members? The answer is yes. So if you were to go back to OSCN, Title 18, Section 1013, 1013, you'll find that exact language that the board, the elected board, can unilaterally amend the bylaws. Now, again, the world divided between HOAs and condos, that is not true for condo bylaws. Condo bylaws are a special statutory thing. So unless those bylaws allow for the board to unilaterally amend, which is, I don't know if I've ever seen that in a condo context. But with a non-stock, non-profit corporation, HOA type bylaws, then statute allows the board to do it. Now, whether you should do it, that's a political question, not a legal question. But on the legal side is yes, the board can do it. So, all right. Edmond has a chicken ordinance. I think Norman has a chicken ordinance. Norman definitely has a pretty extensive HOA, POA ordinance. We're going to fly through that. All right. I'm going to spend a little time on Corporate Transparency Act. If you're not aware of this, you need to be, particularly if you're on the board of your association. But also, if you have an LLC, if you have a corporation, if you're a small business owner, you need to be familiar, along with our HOA boards, of the Corporate Transparency Act. I keep praying each night that Congress will pull its head out and realize that no one in the history of history has laundered money through an HOA, or at least not that I've ever heard of. And so we don't need this for homeowners associations. But however, until I guess someone in Congress listens to my opinion or cares, we've got to do these filings. Now, okay, the good news is it's not difficult. All right. I get it. There's a little bit of heartburn about having to use your social security number, your passport, or driver's license, or whatever. But the truth of the matter is, they, however you define, that government entity, they already have your info. Okay, particularly your social security. This is a government website that you're doing the filing on. It's secure. I will tell you, I went through and I had a couple of LLCs that I needed to do this for, and also I have a number of um, HOA clients who were asking questions about the beneficial ownership interest or information filing. And so I went through and I had trouble with the PDF version of the filing, but I found the online filing really easy. Um,
Matt,
let's see. Yeah.
it's Cassidy at the Neighborhood Alliance. We have had a number of HOAs contacting us and letting us know their management company for an additional $400 or $500 are willing to file this for them. Should they be concerned, and is that a legitimate thing that they could do?
I am aware that there are some managers that are charging several $100s. If someone would like to pay me several $100s to walk them through this website, I'd be happy to do it. But you don't need to pay anybody. It is super, super easy, particularly if you have. So let me just kind of paint a picture. If at one of your board meetings, each of the board members could bring the requisite information, like, and I'm sorry, I don't remember if I used my passport, if I used my social security. I can't remember what I used, but many months ago, I went and I got my FinCEN ID number. So you can go in as an individual and you get what's called a FinCEN ID. And that's where I provide all of this information. So it has my info, and I've traded all my info for this number. Well, it takes a matter of minutes for me to get my FinCEN ID. If the 5 board members, 7 board members, 3 board members, if you know how to go on a website and fill out a form, if you've ever used Expedia and bought tickets for an airplane or reserved a vehicle, if you've done anything like that online, you are more than competent to get this done. Now, I think some managers are charging money and basically just giving you a third party that does it, that you have to complete the information anyway. And so really, what are you paying for? And again, it's entirely free and very, very easy. Once you have that FinCEN number, I was going through and registering my LLCs, maybe 2 minutes a piece. because it goes so quickly. So if you have 15 extra minutes at one of your board meetings, you all could get your FinCEN ID and get your HOA registered, and then
So,
you're done.
and I do have, this is something I think several neighborhoods, I had a neighbor message me a second ago, not publicly, but I know we have several that are having this situation. You stress the importance of registering and listing with the Secretary of State. Um, this neighborhood thinks that maybe they're not incorporated, but they have been filing taxes each year. It's an older HOA. Do they need to do the BOI, and how would they do it?
Okay, so here's I used to be able to say there is absolutely no benefit to not being incorporated, um, except now I have to say, if you are not incorporated, you don't have to file with FinCEN under the Corporate Transparency Act. It's only incorporated entities. Now, this is no reason not to incorporate. So I wouldn't use this as an opportunity to say, aha, we're not going to incorporate, so we don't have to register with FinCEN. That's not a trade-off. That's not a bargain that anyone who understands the issues would want to do. So, for example, if who could I think of that maybe could be unincorporated and not register with FinCEN? If you had like a neighborhood watch group that took donations, $25 donations, you're not dealing with enough money where people would really care if someone spend it improvidently because there's just not enough money to do anything with. But if you have a mandatory homeowners association, now you have fiduciary duties. You're probably talking about an amount of money that if you spend it on yourself, or spent it in violation of your duties, that someone might hire a lawyer. Um, Now everybody's liable. Anyone who's a mandatory member of that association is liable for whatever the attorney's fees, the judgment. I mean, it's all joint and several liability. So, um, if you just simply cannot abide registering the beneficial ownership information, then just get off the board and don't do it. But don't choose unincorporation for for your association. What question? What if we have vacant seats on our board? Will our filing look incomplete? No, it won't look incomplete. It's just you only file board information of board members. So if there's one board member, if there's five, that's the requirement. Each of those individuals would need to file, and there's an update. So if say you have five board members, one of them moves and the board appoints a new person, well, then that new person would need to go through and do the registration and the update. So, but it's just not that difficult, and certainly not worth not incorporating. And it remains to be seen how vigorous the government's going to be in cracking down on people who just ignore the registration. I've never heard of the IRS going after an HOA for not reporting income. Maybe this is going to be kind of like that, but I'm certainly not going to tell a client don't do it. There are very stiff criminal, civil, monetary penalties for not doing the registration. Again, if you'd be better off just not serving on the board than doing it. But again, I think I did maybe half a dozen LLCs in about 15, 20 minutes last Friday. It's a no-brainer. Let's talk about time frame. So the deadline is January 1st, 2025 for any entity that was in existence prior to January 1st of 2024. So if you were created in 2024, you need to do your filing before 2025. If you were in existence before then, you have until the end of the year. So plenty of time. Plenty of time to get your EIN if you don't have it. So it can take a very long time to get your EIN or your IRS letter from the IRS. One of the quick and easy ways to do that would be to go to your bank and see if they have a deposit agreement, see if they have a copy of the IRS letter. I mean, and this is a good idea anyway, because if your bank does not have the HOA's EIN, well, then that means the bank account is under somebody's social security number, and that's not good either. So if your association, if you find that your association does not have an EIN, that is really easy to get as well. You can go online, register for that, and you get the EIN almost immediately, if not immediately. So there's a couple of quick and easy ways to find out the EIN or get it if you don't have it. So that is going to be one of the filing requirements. Let's see. My next slide, basically, I covered all of this. Any other questions about the CTA or the beneficial ownership information? Most of what I'm getting is, well, we're a non-stock, nonprofit corporation, so that means we're exempt, right? No, you're not exempt. In fact, I should have put a link on here. There is a really good frequently asked questions, FAQ, at the FinCEN website. And I can't remember what number it is, but there is one specifically about homeowners association. That doesn't tell you you're exempt, and it doesn't tell you have to file. It's kind of equivocal. But the crux of it is, unless you find a clear exemption, and you can Google this, are homeowners associations exempt from the CTA and BOI? And if you find someone, particularly a lawyer, who tells you that you're exempt, please forward that to me. I'd like to look at it. But most, if not all, attorneys that I've talked to and CPAs, we haven't found a loophole yet. So that is the Corporate Transparency Act and the beneficial ownership information filing. I've talked about unincorporated associations. I'm not going to spend any more time on that. Let's talk a little bit about meetings. This is something that it's kind of built into the lifeblood of associations. And I find that a lot of associations either don't know how to do meetings very well, or they just haven't practiced, or maybe they don't have the tools. Speaking of tools, Neighborhood Alliance has fantastic tools to assist you with figuring out how to do meetings well. So I would encourage you to look for those and avail yourself of those. I'm just going to talk about some of the nuts and bolts things that I see in my practice that either help or maybe hinder having really good meetings. And this is going to go for whether it's an annual meeting or a board meeting, but having regular meetings, consistency. For a while during COVID, everyone was concerned, and it was just a mystery of, well, can we get in a room together, social distancing, all of that stuff. We're kind of out of that now, but remember, that was a really scary time for most people, and it's still kind of scary to some. And so having in-person meeting only, maybe we're as a culture, or maybe beyond that now. And so it's real common to allow for participation by Zoom or by some kind of video conferencing. So the idea is to get as many people there, to get as much information in the minds, hands of the membership, and again, whether we're talking about an annual meeting or board meeting. And so providing an online component, it's super easy to do. We're doing it tonight, and you might think about how your association could do that for annual meetings, board meetings, and that helps serve this idea of your association's purpose, promoting community. Having a written agenda, I find a lot of boards, they dread board meetings or they dread annual meetings because they end up being a shouting match or a free for all. And you would be surprised at how much order and civility can be brought to a meeting just by using an agenda. It's a great escape valve. So what it allows is basically you've got your checklist, and when someone jumps up and says, "Well, what about?" Sounds like you're really passionate about that. I'm going to get to that. And number three, you see that that's on the agenda. So if you can just hold that for a second, we're going to tick these other things off, and then we'll get to it. It's a really good escape valve for board members to, okay, hold your horses, and we'll get to it in a second. What it also does is it allows people, the other people in the room, not necessarily the board members running, but it allows the other people in the room to feel like they're going to get a fair shake and a fair say. Because when the person who has been reminded, we're following an agenda, and I will get to you in just a second, and it sounds like you've got something important to say. When they jump back in, when they demand that their voice be heard, it doesn't matter what the agenda says. It doesn't matter who's running the meeting. If I demand that you hear my voice when I say that, that really sets me up as being an unreasonable person, as a bully, maybe. And so if I'm running the meeting, I want everyone to behave. But then if someone's not going to behave, I want them to make as big an ass out of themselves as possible so that the people around them can see me not getting agitated, maybe getting a little sarcastic with them, but definitely not turning it into a shouting match and not allowing it to be turned into a shouting match. And ultimately, if someone just simply can't control themselves after being reminded a couple of times, maybe they're asked to leave, and then maybe they're forced to leave. What that does is it tells the reasonable people in the room, okay, look, we're neighbors. We're going to give each other a little bit of benefit of the doubt. I'm going to allow, because I put myself in this position, to be maybe this much of a punching bag, but when it's time to stop, when you've decided you're going to be a law unto yourself, well, then that's when the hammer is going to fall. And that if I'm sitting in the audience and I want to see good governance, that's what I want. That's what I want to see. And it really helps set the tone for the meetings and hopefully help people who sometimes just they can't help but twist off. You've set the environment and the culture to where when they finally regain their mind, they can come back and the apology isn't so hard for them. They can say, "Yeah, I'm sorry," and you get them back into um, the reasonable operating mode. All right, how long is a proxy good for? I've got a slide on proxies. We're going to hit that in just a little bit, and I will give you more information on proxies than you ever want. In fact, we'll get that here in just a second. Couple of things I want to say about meetings too. The Open Meeting Act does not apply. People screaming at you either in person or by email or social media that you're violating the Open Meeting, Open Records Act. they're an idiot. It does not apply. You don't want it to apply. It absolutely cannot apply, because if you actually read the Open Meeting Act, it requires the governor to have an annual invitation to your meetings. And the governor's not coming to your HOA meeting. It's got other things to do. So Open Meeting, Open Records Act do not apply. There are records. There is a records request statute in Title 18, but it is not the Open Records Act. All right. Let's talk about meeting minutes very quickly as we work our way to proxies. Meeting minutes are not a transcript. They are not a verbatim, word for word, who said what, when, how. Minutes are what's called prima facie evidence of what happened at the meeting. Was notice given? Did we have a quorum? Were there minutes read and approved? Was there a motion? Was there a second? And was it adopted? Not Matt said this and was very agitated, and then Jane said that and she was equally agitated. It is not a soap opera or a drama or verbatim. And in fact, the more words you commit to those meeting minutes, the more problems it could create if there is a dispute. So just make it simple for your secretary and just keep it light and topical. And that's all meeting minutes need to be. I'm going to skip this stuff. Quorum, if you're not familiar, quorum is the minimum number of people who need to be in person, who at a meeting in person or by proxy, in order to conduct business. One of the things with quorum that we look to do is this diminishing quorum provision. And actually, this gets back to unilateral board member bylaw amendments. This is the number one reason we will assist boards in amending the bylaws, is so that they can actually get a quorum and conduct business. I won't ask for a show of hands because y'all don't have your cameras on. Don't turn them on. But how often is it that you don't have a quorum at your annual meeting and you just do the best you can and you just continue? That's very common with homeowners associations. And it's usually not a problem until you want to enforce the covenants, and then some enterprising defendant or lawyer's like, hey, wait a second, you can't tell me no, even though I've been paying my dues to this association that I'm now claiming is defunct. You can't tell me, what I can and can't do with my property because you're not duly elected. And then we have to litigate all of that, which is not a valid defense. It's like saying, well, I think there was a contested election for the governorship in Oklahoma, therefore I don't have to follow Oklahoma laws. Well, that's not exactly how it works. So one of the things that we will do with quorum provisions is look at your actual quorum and see if there is this diminishing quorum dealing with or stemming from the kind of notice that you give. So it's possible under some bylaw language, quorum provisions, that you send out one notice and it says something along the lines of, we're having a meeting on January 1st at noon. If a quorum's not present, we're going to adjourn, and then call the second meeting at 12:05 on January 1st. So that you give one notice and you hit all of the notice requirements for that diminished quorum. Now, that only works if your bylaw quorum provision allows you to do that. If the diminished quorum provision requires notice to be sent out no less than 10, no more than 30 days from the adjourned meeting, well, then you can't do it. You can't just send one, because you actually have to send it no less than 10 days. So you just have to make sure that your bylaws allow it. If they don't, the board can amend it, and then we can be off and running and doing actual business. All right, question, is it 1/3 of the members who are eligible to vote? So it depends on if that's what your quorum provision says. So sometimes there's something called a member in good standing, and it will say that if you have to pay your dues or otherwise be in full compliance with the governing documents, and if you're not, then you're not a member in good standing. We just have to read that clause and determine, does that affect quorum? Hopefully our quorum says 1/3 of members in good standing. Sometimes it's not clear and we have an ambiguity, and that means we should amend to make it clear, right? Next question is, we changed the quorum as the persons present plus proxies, not an actual. So basically what you've said is the quorum is the people who show up. I don't know the answer to this. And you have a lawyer on record now saying they don't know the answer to something. I don't know how that shakes out. I can tell you what I think about that, and I would prefer there to be an actual number that you know you're going to hit every time. This, if it's the people who show up that are present plus proxies, you could have one person show up, and now you've got one person doing business on behalf of the association. So typically what I'd like to see is 1/3, 1/10. 1/10 is really easy to hit. I'll tell you what I do, kind of my sleight of hand, as opposed to saying, quorum is whoever shows up. What I do in my bylaws is, with my developer bylaws, is saying quorum is 1/3 or 1/10, 50%. It doesn't matter what the percentage is, but that anyone who doesn't appear or submit a proxy will have been deemed to have given their proxy to the chair of the meeting for quorum purposes. So now we will always have a quorum. It doesn't matter who shows up, because you either show up, you either give us your proxy, or we're going to count you as having given your proxy to the chair for quorum purposes. So that's how we handle that. I can't tell you that that's wrong, that you can't do it. I'm a little uncomfortable with the whoever shows up. That's going to be our quorum. So, all right, proxies. Let's talk about proxies. So we do have a statute on proxies, and in Title 18, you can go read it. Basically, a proxy is anything that is either a hard copy or electronic. You cannot have an oral proxy, but virtually anything else is fine. Text message, email, Sharpie on a cocktail napkin. It is all fair game for proxies. Don't let anyone ever tell you the only proxies that are acceptable are notarized. Someone who's telling you that is someone who's trying to control an election, is what I've found, or someone who just doesn't understand what the law or what proxies are. So proxy can be just about anything. And this is where that unless otherwise provided language comes in. So in Title 18, Section 1060, unless the proxy says otherwise, a proxy is valid only for 3 years. So you could execute a proxy that says this proxy is valid only for the next meeting and any adjournments thereof. Well, that proxy is going to expire after the first meeting and any adjournments. So if it doesn't say anything, that's going to be valid for 3 years. So different kinds of proxies. You can have an enduring proxy, which means it goes on or terminates after 3 years if it doesn't say anything. It can be a limited proxy. I give you my proxy for quorum purposes only, not for voting. It can be a voting proxy. It can be what's called a directed proxy. I give you my proxy for quorum purposes and direct that you vote for, against, whatever, for purposes coming before the meeting. The only time a proxy might be deficient, and you got to think about this, is so for example, um, if I want a certain measure, whatever, or motion to be voted on by my proxy, and I have directed that they are to vote for this particular motion as it was communicated, it is possible, this doesn't happen very often, but it is possible that at the meeting, the motion gets modified. And now my proxy holder is sitting there with a proxy that directs them to vote for a particular motion that is no longer before the body. So think about that with your proxy giving, or if that's an issue, just go to the meeting yourself, and then you get to decide how to vote. Yeah, text message giving proxy, okay? Yep, absolutely. So text message to the secretary, text message to a friend, all of that's fine. There has to be some kind of uh, substance to it, and it can't be ambiguous. You want to make it clear that it's from you. This is why having a piece of paper, a formal proxy, you take away a lot of the ambiguity, but text message, email, that can certainly work. Um, wow, I've got a lot of slides, and there's so much information to cover. Let's start talking about enforcement. We've got about 20 minutes left. This isn't going to be the extent of the enforcement discussion because I go into a lot more detail on this in part 2. But some of the questions that come up that I hear in my practice a lot is, how do we enforce the governing documents? What kind of teeth do they have? Is the association authorized to do this or that? And then some of the questions that I ask is, do you want to? Have you considered the cost versus benefit of doing this? Is there a path to recover attorney's fees? And is this an issue where perhaps we need to consider lot owner enforcement versus association enforcement? And the classic case that I use for lot owner enforcement is neighbor's dog is barking incessantly. Adjoining neighbor contacts the board and says, hey, our covenants have a no noxious or offensive activity or annoyance to the neighborhood clause. My neighbor's dog is being noxious, offensive, and is annoying me. Can you do something about it? Most times the board is not going to get involved in that. Most times the board should not get involved in that because the issue is so localized that it's really something that the two neighbors need to handle themselves. Now, sometimes what comes back from the aggrieved owner is, board, do this or else. Well, the only or else is, or else I'm not going to vote for you in the next volunteer non-compensated board election. That's the or else that they get. Sometimes what they think is, or else I will get my mean, nasty lawyer to sue you. You can do that. There's no lawsuit there. Just like there's no lawsuit against an individual for taking this vacation versus spending their money on that car. That's their discretion. They get to decide how they spend their money. Vacation, car. The board gets to decide how the association spends its money. Flowers, lawyer. That's the board's decision. That's business judgment. Okay. All right. So one of the reasons why, let's talk about expand a little bit about the barking dog and why boards typically will not jump in the middle of that as far as an enforcement goes. But sometimes what the board can do, back to this idea of, okay, the association's purpose is to promote community, is help facilitate neighbors treating their literal neighbor as their neighbor. and the board can facilitate communication, help think of possible solutions, resolutions, but keeping in mind that one of the best things a well-balanced, reasonable board can do is realize when they're hearing one story that it is entirely possible there is another side of the story. Really good leaders, conflict people who tend to resolve a lot of conflicts or at least manage conflict well realize it's not often just two stories. There's three stories, one side, the other side, and then the truth. And this picture illustrates the problem with believing a one-sided story. And from one angle, it looks like he's giving the American bird, and then from another angle, he's giving the British three. So really good illustration of a guy with a fantastic haircut and two different points of view. So let's talk about some of um, the initial steps or the things to consider other than we're going to file a lawsuit, we're going to win and get all of our money back kind of idea of enforcement. So enforcement in our mind is simply getting people to do what either you think they should do or what the covenants say they should do, and however that happens. Well, the best way to get that to happen is not paying a lawyer, not submitting it to a judge or a jury, and them just doing it because they want to or because they think they're supposed to. Not even so much that they're doing it out of fear of attorney's fees, but that they want to. It's just what you do in our neighborhood. It's just what you do to be a good neighbor and pay your dues on time in the right amount. It's what you do as a good neighbor to submit an architectural review application and wait to get approval before constructing something. It's not daring others to enforce the covenants against you. It's not throwing your weight around. It's basically going along to get along and doing what you said you were going to do, and that's follow the covenants when you purchase the property. So convincing people that that's how we operate and that's how you should operate, and how just we make this neighborhood wonderful and a great place to call home. That can start at the closing. And so providing information, a welcome home letter, whatever you call it, whether it's a basket, an actual basket of something or virtual basket information, whatever it looks like, it's going to have to suit your personality of your neighborhood and your pocketbook and your volunteer capacity. So if everyone works full-time jobs, has full-time families, then maybe it's just hey, we're happy for you to be in our neighborhood. Please sign this to provide us your contact information. By the way, here's some important information you need to know about our neighborhood regarding the covenants, where to send applications for design review, what that means, considering the fact that this person may not have any idea that there's a homeowners association. And that's a perspective that I want to see on at least a board of an association in a neighborhood that I live in, is consideration that I may have absolutely no idea what the right thing is. And maybe this is my first home. Maybe I have worked my tail off to buy a house in this neighborhood, and I've never lived in anything other than an apartment until now. What I don't need is to be scolded. I don't need to be sued because I'm 30 days late or a lien filed against my property because I'm 30 days late on dues. What I need is an education. And depending on how that education comes, You may have one of the most devoted, loyal, service-oriented people now on your side to help you operate the association, or you could completely alienate me and leave a bad taste in my mouth, and I'll never have anything to do with it. So, how we approach these situations, yes, people should know what they're getting themselves into. Yes, people should know how to drive on the highway when they get a driver's license and they get on, but maybe it's their first time and maybe they're just, not as great a driver as you, whatever analogy you want to use. But to me, enforcement is included in communication in such a way that we have won this person over and they will never have to be the subject of a demand letter. All right, so let's go to the next one. And these are some enforcement truths that I have found in my practice. And it's worthwhile thinking about this because as litigators, we find fairly frequently that people, whether you're on the association board, whether you're an individual defending against your association, whether you're individual trying to get your neighbor or another individual to follow the covenants, everybody thinks they're going to win and they're going to get all of their money back. And even though your lawyer tells you, okay, there's risk here. There's always risk in going to court. No lawyer can tell you you're going to win. And then when you follow it up and say, well, is it a 50-50? No lawyer should answer that question because any answer is just making it up, unless it's, I can't give you a percentage. It is simply a made up percentage. What we can tell you is we've gone to court and won cases that in our gut thought there is no chance we're coming out of here with a win. And we have come out of court with a loss on a case that we just knew in our gut there's no chance we can lose this. And so you just never know. And it's kind of like the investment prospectus. Past performance is no guarantee of future results. So one of the truths that there's some of the truths that I think we have to wrap our mind around when it comes to enforcement is just because there are words on a page doesn't mean that we can make people adhere to them. It is entirely possible that you have a black and white covenant that, say it says weathered wood colored only shingles. That's a very common covenant. And it's possible that the language on the page is abundantly clear, it's not ambiguous, and there are a handful of reasons why you couldn't enforce that. One being you couldn't afford the $50,000 or $75,000 that your opponent's about to spend or willing to spend in order to litigate this roof color shingle issue. It could be that there's half a dozen OSU orange shingles on houses, and weathered wood only shingle covenant has now been waived. So just because the language is there doesn't mean that it is now enforceable. All right. The second, and this is where this is a difficult bullet. Relationship is less expensive and more certain than litigation. That is true. However, relationship is often much, much harder than going through litigation. And what I mean by this is relationship requires closeness, it requires communication, and a lot of times what people are paying for in litigation is for someone else to do their talking and someone else to do their decision making and conflict resolution. That's exactly what you're getting in court. However, if you're short on cash, which most associations don't have $50,000, $75,000, $100,000 litigation budgets, then you're kind of forced to focus on relationship and what that looks like. This isn't about giving up on ideals. It's not giving up on covenants. It is looking for means within the bounds of the parameters or the covenants or the restrictions that you're operating with, whatever the circumstance is, and looking for ways to resolve the conflict. We have, and this is, I think, harder today, just culturally, because people think that any kind of conflict, it has to mirror the intensity that we see political conflict or geographical conflicts, that it has to match that intensity. And that is a lie. Um, our conflicts with our neighbors don't have to reflect the discourse, the lack of civility that we see among politicians. I mean, you're not campaigning. All you're doing is trying to live as neighbors should live with one another. And so this idea that, well, this roof shingle is the hill that I'm going to die on. Actually, more accurate, this is the hill that I'm willing to kill everyone around me on and burn this place to the ground on. That's a lot of kind of the attitude that we find with some enforcement, and it doesn't necessarily need to be that way. So the second, aesthetic harmony, what is a nuisance, is kind of like beauty. It's in the eye of the beholder. And this is why some associations, some association boards validly will come to the conclusion that, okay, look, even if we were sitting on a pile of money, we just don't think that your neighbor's sunflowers that are poking over the backyard, or the swing set, or the basketball bouncing, we just don't think that that's an issue that we're going to get involved in. And if we can help you somehow better communicate with your neighbor and possibly come to a resolution, well, absolutely, we want to help with that. That's the business that we're in. So it is shocking. And this is a truth that I'm reminded of repeatedly. And every time I shake my head and think, man, you've got this on a slide and even you don't get it. I am shocked at how often some of the what seem to be the most intractable conflicts get resolved by simply communicating, whatever that looks like. Sometimes it's an email among attorneys and, hey, can we get together and talk about this? Sometimes it's one litigant deciding, you know what? I get it that there's this idea it's going to make me seem weak if I approach this person and simply say the words, hey, we're about to spend a whole lot of money on this lawsuit. Is there something possibly we're missing? Or can I spend 10 minutes and listen to your side of this, and maybe we can come to some resolution or some agreement? I am shocked, and I'm not overstating that word, how often that works. Or we see something that maybe not gets us the entire way, but helps maybe minimize time and cost. So whatever that looks like in y'all's particular situation, then I have found that to be true. Something that is often, this will probably be this will be the last slide that I cover tonight, and then we'll pick it back up on Thursday. It's very important that you read through your governing documents. In fact, I suggest that board members, whether you're new or old, if you've never done this, this is a great process to go through. Get a 3-ring binder, get all of your governing documents, create an index so that they're all well organized and tabbed, or even if you don't do all of that, have a set of your covenants and your bylaws and read them top to bottom, and do it with a highlighter. And every time you come across the word shall, highlight it, because in contracts and in covenants, the word shall is a mandatory, non-dischargeable obligation. It's a non-delegable duty. And so it's a good way to learn, okay, what is it as a board member that I have to do? Well, what you have to do is going to be associated with a shall in the covenants and the bylaws. And so if you come across a clause that says prior to the enforcement or prior to any penalty being applied against an owner or a property, the board or the association shall provide an opportunity for hearing. Well, that's called a due process clause, and you have to do it. It is a precursor. It is a requirement, a non-delegable requirement before you file a lawsuit, before you file a lien, before you do any kind of penalty. Take away their common area privileges, their clicker for the front gate, so now they have to suffer the indignity of punching a keypad to get to their private gated community. Whatever the enforcement or penalty is, if your governing documents require due process, you got to give it. Okay? And you want to make sure that you give it in the particularity that the governing documents require. So if it says a hearing en banc, and you don't know what en banc means, then learn and make sure you follow it. Basically means the whole board. If the notice requirement for your due process requires service in like manner of civil process, don't think that that means you can simply send something in the mail. If you have language that says shall serve written notice or shall give written notice in like manner of civil process, well, then that means you have to serve them. Either hire a process server or you have to send it certified mail restricted, and they actually have to sign it in order to have good service. So these are things that you don't want to find out, whoops, we didn't give them the due process once you have filed a lawsuit. You make sure that you follow the due process, which, by the way, a lot of defendants are going to claim that you didn't give them due process, even if you spend an hour with them giving them due process and you video the whole thing. You can't be concerned about that. That's on them. What you have to do is make sure before you file the lawsuit that you have checked all those boxes, which is one of the things that you rely on your attorney to do. So I think that's about the end of our period. So we will pick this up for an additional 2 hours on Thursday. I'm going to take a deep dive into assessments, the different kinds of assessments. We're going to talk about liens, foreclosure, bankruptcy, insurance, the specific types of judicial enforcement. I know I nibbled around all the edges and hopefully convinced you that you don't want to spend a lot of time before you go to court. Well, what happens if you do all that and it doesn't work and you still have to go to court? We're going to talk about that. So if I didn't get to a question or you were shy, feel free to put it in the chat and we will cover it next week. So with that, I am going to exit out and wish all of y'all a good evening.
Just now getting on. So welcome everybody tonight too.
Hello, hello.
Hi, folks. How is everybody?
Hi.
Having fun.
Doing good today.
Good. Hi, Cassidy. Hi. Who you guys?
Munchie.
And there's one more. Our Norman primarily works in Norman. Mary Catherine right here is also on. So she works with a lot of the HOAs in the Norman area now.
Great. All right. Well, I will go ahead and just jump right in. Let's see if I can share my screen here. Everybody hear me okay? All right, good deal. Oops. I'm getting there. Okay. All right. I think I've gotten us there now. All right. So I'm gonna blaze through the initial disclaimer again. It's not legal advice. You can find all the resources either in my email signature or on the slides when they get posted. Excuse me. So, like a couple nights ago, if you have questions, just feel free to put them up in the chat. I will pay attention and catch those as we go along. As I introduced last week, the topics tonight are going to get a little bit more in depth with some of the major categories that we routinely experience in community associations and association law. And that's assessments. How are the associations financed? Insurance. How do we properly insure the association, both from a casualty property standpoint and liability? And that includes directors and officers. And then we will talk about judicial enforcement. We talked a lot about the precursor to enforcement a couple nights ago. We'll talk about some of the nuts and bolts with litigation. And really, this is where the disclaimer comes in. So I get it. I would be the same way. A lot of people want to know, hey, are we going to win the lawsuit? And it is so fact specific. It is so economics driven, and there's just so many factors. All we can do is talk about some generalities, some of the courses that a lawsuit might flow, but we certainly can't drill down to, well, of course you can enforce that covenant, and of course you're going to win. We simply can't get to that. Then we're going to talk about amendments. So one thing that is always an option, if we have covenant language that nobody likes or that nobody listens to or nobody wants to enforce, well, then it may be that we just need to change that covenant language. And it's always possible to amend covenant language. Maybe not practically possible. Sometimes it takes 100% approval. Sometimes it takes a simple majority. And like we talked about last part one, last session, sometimes it just takes the declarant saying, you know what, I'm going to exercise my unilateral right to amend the covenant. So we'll talk about covenant amendments. I have this slide just to remind us of what the law is. And I do this not to simply be repetitive, but when we start talking about covenant enforcement, a lot of times I'll hear, well, I read on the internet, which is always a bad way to start a point that you're making. And then second, well, we know across the street they did such and such in court, and this was the result. And that might be true, what you're actually saying, but the fact that that is true and that it would be true in your case is not necessarily logical, or it doesn't necessarily follow that, well, simply because that neighborhood did this or that, it's going to happen or won't happen in your neighborhood. That's not how court works. And just because your neighbor across the street or in the next neighborhood was able to enforce a covenant doesn't mean even the same covenant could be enforced in your neighborhood. It might give us some good ideas on enforceability, how a court could look at it. but not necessarily so. Okay, so that's why I put this up. If you want to find the law are statutes and cases that have been published. All right, so let's talk about the financial aspect of associations for a little bit. So if you were to go into Oklahoma law, the statutes, that is, and you were to look up what are the laws relative to special assessments in Oklahoma, you're going to spend either a very short period of time realizing it doesn't say anything, or you're going to spend forever trying to find it, and you will never find it because it's not in there. The statutes, both for condominiums and homeowners associations, say nothing about special assessments. They don't even use the term annual assessments, but they talk about this periodic monetary charge that we often refer to as annual assessments or dues. If I happen to lapse into using the word dues, I'm talking about annual assessments. But that's only one small part of the financial picture for an association. So the regular annual or monthly assessments is one. Special assessments is a very common clause or slice of the financial picture for associations that we find drafted into covenants, sometimes in bylaws if we're dealing with a condo. But most of the time when we're talking about special assessments, we're talking about a type of charge that deals with capital improvements or possibly a budgetary shortfall. But we really have to pay attention to the language in the covenant clause itself. I have a condo association that I represent in Tulsa County that has a special assessment clause in its declaration and bylaws, and it has two paragraphs in it. The first paragraph deals with this traditional special assessments that we think. It's a uniform charge against all lots or units. It's only applicable to 1 year. Sometimes there's language that it's limited to a percentage or 1.5 times the annual assessments. That's a real common and typically what we're looking for, what we understand or expect to find for special assessments. But this condo association has a paragraph 2, and the paragraph 2 really isn't a typical what you'd expect special assessment. It deals with monetary penalties or fines. And that's this next category of financial, the part of the financial picture for a community association. And that's this idea of fines or specific assessments. Sometimes they're called individual assessments, monetary penalties. But with this Tulsa County condo, they use the term special assessment. So it really doesn't matter what the name of the clause is, what the heading of the clause is, but we really have to read the language and make sure that we're understanding the language. And when it comes to special assessments, some of the things to watch for is it a special assessment only for 1 year? Because it's real common, special assessments, there's several $1,000s or can be several $1,000s per unit or per house. Well, a lot of people don't have that money just sitting around. And so it's pretty common for special assessments to be strung out over a period of time. Well, the question arises, if you have language in your special assessment clause that says it is only for 1 year, do you have to re-vote and adopt the special assessment in successive years if you're going to allow payment over a period of time? In other words, do you actually have multiple special assessments? And if you try to have one vote and allow it to be charged over multiple years, are you running afoul of your special assessment language? So that's something to watch out for. The other thing with special assessments is if the language says it's only can be used for capital improvements, well, running out of money at the end of the year is not considered a capital improvement. It's just a budgetary shortfall. So if you have a special assessment clause that limits to just capital improvements, well, then you can't use it just to raise money because you don't have it. All right, so the specific individual monetary penalty fine language, that is unlike special assessments, it's just for violations of the covenants, for damages perhaps caused by an owner or an occupant or their guest or their family. It's a charge to either compensate the association for a cost, and this isn't necessarily in a negative context or punishment or enforcement context. Sometimes individual or specific assessments can go for something really positive. So, for example, if you have, say, a cul-de-sac, and there is, some private area in that cul-de-sac, say it's a planter or a small little park or yard or something. It's not common area. It's not owned by the association, but the individual owners want to pool their money and have it maintained, and they want to have it maintained to the level or standard of the rest of the common areas. Well, then if you have specific individual assessment language as opposed to using a special assessment, then maybe the association will absorb the cost of maintaining whatever it is this area and then turn around and bill it just to those owners. So that would be a non-enforcement, non-punitive use of specific or individual assessments. So and again, I want to be clear, the takeaway from this conversation isn't, oh, great, the lawyer said there's such thing as specific individual monetary penalties and fines, so we're going to start doing that. No, you can't. Just like you can't charge special assessments if you don't have that language in your covenants. So you don't get to just make it up because it's available out there. You actually have to have the authority and the right, and then you have to follow that, whatever that authority and right is, whatever the parameters are in your covenants or in your bylaws. So, and I can't remember if we discussed this last time. I'll go ahead and say it now at the risk of being redundant, but monetary penalties and fines cannot be tucked away in bylaws unless it's a condominium and they're recorded. It must be in covenants. It must be adopted by the lot owners or unit owners. This monetary penalties cannot be just thought up and enforced by a board any more than just made up late fees for not paying your dues on time. If the covenants don't provide for it, then you don't get to just tack it on and then file a lien based on those made up fees or fines. By the way, the board needs to make very certain that the management company you're using understands not only the proper procedures for filing liens, meaning the manager doesn't have the right to just sign a lien and file it because you're manager, any more than a husband or wife or spouse has the right under the law to sign a deed and file it on behalf of their spouse. The law is very clear on how this works, and it doesn't work off agency. So that's one thing. Second is make sure that you're following the bankruptcy code and the Fair Debt Collection Practices Act. If your manager doesn't have practices to observe those, you should probably shop your management around, because violation of federal law comes with pretty stiff civil penalties. So the fact that there's this idea out there, and not only just the idea, but that some associations have the ability to assess fines, monetary penalties, and that some associations have the ability to charge delinquent interest or late fees, doesn't mean you just get to make it up and then file a lien against someone's property because it's effective. Of course it's effective. So is putting a gun in someone's face and demanding their wallet. It's not that it's not effective. It's that if your covenants don't authorize it, it's illegal, just like robbing someone at gunpoint. All right, quickly, I'm going to go over some of these bullet points. In fact, I was just telling a client this today. It's been many years since I've seen ledger sheets on a collections client, but in my career, I have seen that. If your association is still using handwritten ledgers for your assessments accounts, let me encourage you to either hire a bookkeeper or explore the world of Excel or Quicken or something like that. Makes it so much easier to keep track and avoid mistakes in accounting. But having some kind of accounting system so that you're tracking owner payments, it helps with collections. In fact, getting back to Bankruptcy Code and Fair Debt Collection Practices Act, we will have to have accounting, clean accounting, going back to zero, in order to make sure that the association's not trying to collect fake debt, time barred debt. I believe we get to this on a later slide, but I'll go ahead and mention it. So having a clear tracking of when people have paid allows us to determine if the amount that is owed is time barred, meaning barred by the statute of limitations, which is a Oklahoma statute 12 OS 95 that says if the debt uh, exceeds 5 years in delinquency, well, then you can't collect beyond 5 years. It's a 5-year statute of limitations on association collections. And if a person pays $1, then that reinvigorates the debt and it allows us to reevaluate that statute of limitations. So it's very important to have accurate tracking, not just from a customer service standpoint, being able to give accurate communication to an owner or owners on where they are, but also communicating accurately in a timely manner to title companies. That's a very easy way for the association to receive payment on accounts. If you're not familiar with it, title companies want to communicate with homeowners associations anytime there's a closing so that they know they are properly accounting on the HUD-1 or the closing sheet who pays what. And so having a website, having social media, having these various ways that the association contact can be found is very easy these days, and it's also very important. So having a website that, because that's what everybody does. You go to Google or maybe Yahoo, but you go online and you Google Happy Acres Homeowners Association treasurer, and that kind of search needs to lead them to you. There is a means of setting up a Google business address or ID, and so that might be a means for your association to get recognition. So anyway, having the ability, yes.
Oh, may I just interject real quickly since you said that? We are looking at potentially, we don't have a date for it yet, putting out a workshop on basically setting up digital neighborhoods like your website, you're looking at social media and things like that. So if any of you struggle with that, just be on the lookout. We'll send out emails because that's something we touched on today.
And to go off of that, Maya, as well, he's talking about email addresses. One thing we've noticed often is a lot of neighborhoods will do something like first name at, loneoakhoa.net. Well, Ashley might not be there forever. So we will also be talking about in that class, like streamlining even that process to make sure that there's always someone to be reached.
Perfect. Excellent. Thank you for jumping in. One thing that I'll tack on while you're talking about email addresses. So something that you can do with Gmail is, and this goes to your comment about Ashley at gmail.com or whatever. If you have a board.happyacreshoa@gmail, what you can do is that email address stays forever and that doesn't change. But what you can do is internal to your Google account is change where that email is pointed to. And so it's a really good way to have this one static address that title companies, realtors, your lot owners, they it doesn't change, and so they will continue using it. But you can go in and point that to different email addresses. So
And it's got
that's it.
functionality for spreadsheets.
What's that?
And it's got functionality for Google Drive, which is essentially a spreadsheet.
Yeah, that's right. All right, here's a comment. So in giving info to title company and someone is 10 years behind in HOA dues, we can only collect 5 years. Um, the technical answer is, or I guess the quick answer is yes. The technical answer is maybe you're limited to 5 years. So it really depends on the history. So if you have a 10-year-old debt, 5 years of that is going to be time barred. However, if you have that person who owes 10 years, they come in and they say, you know what? I realize I've never paid. I feel terrible. I've been using the pool or amenities without paying for them. Here's $1, and I want you to contribute this towards my debt, and I'm going to work on this. I'm going to do better. Well, under those facts, they have reinvigorated the debt and basically affirmed it, not affirmed it in a bankruptcy setting, but in terms of acknowledging the debt, and now they're liable for it. So this is why in the world of debt collection, sometimes we hear boards take the position of, no, we don't do payment plans. They owe the money, they pay it all now, or we move forward with enforcement. You could do that, but it's not the wisest debt collection practice. You get people paying, and because number one, it helps them. It's like the test drive. It's the debt collection test drive where they're in the car, they are picturing themselves driving. Now they're paying, they're working and chipping away on the debt, and now hopefully they can see themselves getting out from underneath it. That's the goal of debt collection, is collecting the money, not making people feel bad, not piling on fees or even attorney's fees. So any of those practices that you can do that keeps lawyers out of the mix, people are generally happy and will pay less. So overall, so yes, you can collect 10-year-old debt, but most of the time it's going to be time barred. One of the follow-up questions to that sometimes is, well, we have a lien, and so we will get paid when they sell their house. Well, a lien only evidences debt. A lien does not preserve debt, and this is on a later slide, but I'll go ahead and say it now. So the fact that you have a lien doesn't do anything for the statute of limitations in 5 years. Okay, and in fact, getting back to debt collections, if you have your manager file a lien, either because you just found out someone filed bankruptcy, then you and your manager have violated the bankruptcy code. And then if the debt is 10 years old and you have them file a lien on that 10-year-old debt, well, then that violates the Fair Debt Collection Practices Act, because you can't collect fake debt or non-collectible debt. So it's a really good idea to get legal advice when it comes to legal questions and not rely on non-attorneys. How do we get incorrect info of ownership corrected at the courthouse? I might need you to add a little more facts to this. I could guess maybe that you have incorrect info as to who owns the common area, but I'll tell you what, I'm going to keep moving and you update the info. Give me a little more facts, specifics on what you're talking about, and I'll try to get you an answer. All right, so I've talked a bit about collections, and I've hit some of these. It's very important to make sure that when it comes to collections, that we are collecting real debt, not time barred debt, not this ubiquitous $25 late fee that if we go to the covenants, there's no mention of a $25 late fee. I don't know where this comes from, but you need to conceptualize just tacking on late fees when they're not authorized by the covenants is the equivalent under the Fair Debt Collection Practices Act of putting a gun in someone's face. This is why we have these debt collector laws that make it illegal and punish debt collectors that call in the middle of the night and say, I'm going to put grandma in jail unless you pay this debt. I mean, you can't do stuff like that. You shouldn't do stuff like that, whether the law provides for it or not. But we see this $25 late fee, and even worse, we see it translated into liens and filed against people's property. Bad idea. There are significant civil penalties. There's a cause of action called slander of title, where the worst case scenario is, interest rates have been really high. You've got a couple who have been underwater on their mortgage. They're just waiting to refinance, and the association files this lien with fake debt on it, and it keeps them from refinancing to a lower interest rate. That is a classic slander of title, and the association could get really punished monetarily for stopping that closing, and could be liable for significant money damages. So it's not hard. It's not administratively burdensome to get this right, but you do have to know what you're looking for. And some managers do know how to do it, some do not. All right. One thing, though, for certain, whether it's your lawyer or your manager, they need to understand how the bankruptcy code works, how to check for bankruptcy. So when a person files for bankruptcy, there's something called the automatic stay, and it's a quiet time. It is a statutory quiet period, a moment of peace and catch your breath from your debt collectors. And it's called the automatic stay. And you can't file a lien with the automatic stay in place. You can't send a demand letter. You can't do any of that stuff. The purpose of the automatic stay is to prevent it. And so your manager sending a demand letter, your lawyer sending a demand letter, filing liens, that all violates the automatic stay, and bankruptcy judges do not like it when people violate the automatic stay. So be wary of that. All right. Let's check the. All right. So section 1 has I'm reading the comment here, a little more information. Section 1 has a different name and address than section 2. Name on section 2 is not spelled correctly. Neither owner address actually goes to the HOA, but to the developer. Okay. So we're talking about the assessor's records. So a couple of possibilities. One, maybe the assessor just has the information wrong and you can update them. However, most assessors get their information from the county clerk's records as to what the name of the entity, owner, or person who owns the property. Sounds like we're talking about common area, but a lot of times what we can do is contact the developer and have them do either a correction deed, or actually maybe it's a first deed, and do a quitclaim deed from the developer to the association, hopefully get the name right. If the name is wrong, the developer's long gone, there's no possibility of convincing the assessor to get the name right, then it may be one of those things that it is what it is, and I hate that phrase, but it may be something that just simply needs to remain because it would be so cost prohibitive to fix it. One way, and I don't know if this would work in this instance, but one way you could fix it is there's a fairly inexpensive filing at the Secretary of State's office. It's called a trade name report. Basically, it's a DBA. Think of it in terms of an also known as or a DBA. that's a trade name report at the Secretary of State. So if your association is incorporated, and if you'll remember from part 1, your association should be incorporated because you were going to go check. And if it wasn't, you were going to incorporate on Wednesday before we got here on Thursday. So if it's incorporated, then you can file a trade name report, and you would use that trade name report as this, whatever the wrong name is. So this isn't ideal, but it is a fairly inexpensive way of curing name problems that we can't otherwise fix. So you would have Happy Acres HOA Inc. And if the assessor or if the developer had deeded the property to, say, Happily Acres Property Owners Association, and it's clear that they intended to get it to the HOA entity, they just got the name wrong. Well, you could do a DBA or a trade name report or Happily Acres POA, and at least that will tie everything together. And so you say it's listed 2 different ways at the Secretary of State. So if sounds like we've got a bowl of spaghetti, you may want to fix it at the Secretary of State's office first, and I would have to dig in and look at it. You could do a consolidation, a merger. There's different means of getting those 2 entities merged into one. You could ignore, or not ignore, but you could disregard both of them and take them into one entity. So there'd be a couple of ways of fixing that. Odds are, though, in a lot of instances, this stuff has gone on for 20 years and it's not caused any problems. It's not to say it couldn't or wouldn't in the future, but you just have to evaluate what's the cost benefit of taking steps to finish it. Yeah, typically anybody on the board, whoever has authority, could do those filings. Trade name report, it does have to be someone with authority, but yeah, board members would. All right, so let's talk about liens for just a second. I've covered a bit of this. You don't have to file a lien year after year. If you're paying someone to file a lien year after year on the same account, you're wasting your time and money. You file one lien. It says Matt owes X number of dollars, and this lien is to secure the repayment of that, plus all late fees, attorney's fees, interest, and future unpaid accruing assessments, costs, all of that. So you have this continuing lien language. You don't have to file it year after year. These are filed with the county clerk where your property sits. These are not mechanics liens or MMLs, mechanics, materialmen, laborers liens. That is a completely different kind of lien. And so if someone's telling you, well, either you have to foreclose the association lien within a year, no, you don't, they're thinking of an MML. Or if they tell you, well, you can file a lien, but you can't foreclose on it, no, that's just completely made up. Unless for some reason someone was nuts and filed covenants that actually said that. I've never seen covenants drafted that way. There's no reason in the world to do that. But Oklahoma law expressly provides, both for condominium liens and HOA liens, that they may be foreclosed. So it is certainly true in Oklahoma, no matter what you hear from anyone, lawyer or not, or what you read on the internet. In Oklahoma, you can lose your home, meaning it gets sent to sheriff's sale for not paying your HOA or condo dues. Now, whether that will actually happen in a given case is more an economics question. We don't file very many foreclosure cases for HOA liens, but certainly for condo liens. And that's because condominium assessments are typically much, much higher. They're on a monthly basis. They include a portion of insurance, simply because the structure for condos are much different than the the ownership structure in a single family HOA development. So, all right, already talked about who signs and foreclosure. Let's talk about association collections. Typically, this happens in small claims court, and your board members could file this. The way small claims court is designed in most states, and certainly Oklahoma is included, is it's intended to be accessible without an attorney. In fact, some states you cannot take an attorney to small claims court with you. Oklahoma is not like those states. You can take an attorney to small claims with you. And if the other side has a lawyer, you definitely should take a lawyer with you. You don't want to appear in court with an attorney on the other side. Typically, pro se litigants don't do that well when there's an attorney on the other side. So the association could bring its own lawsuit. Small claims jurisdiction is $10,000. That is a lot of dues in most associations. In fact, it's a lot more than 5 years worth. So a lot of cases get filed in small claims court for association collections. There are some things to watch out for. If you do hire a lawyer, attorney's fees are limited in default cases, meaning the defendant gets served and doesn't show up to court. There is a statute in the Small Claims Procedures Act that might limit attorney's fees. This also is where it helps to hire an attorney who does this for a living and not as a side gig or just as a marketing ploy. There are arguments that could be used and are successfully used to help the association recover as much money as possible, meaning the cost of collection, attorney's fees. Once, whether you hire an attorney, whether you get the judgment on your own, if you've ever been to court, it may have been a little less than satisfying because what you get is a piece of paper that says this individual now owes you money. The judge, in most circumstances, isn't going to order that person to pay you. Definitely not on the day of trial and you get your piece of paper. Maybe at another time, there's a procedure that your attorney could use to get the judge to order the defendant to pay. But you got to collect the judgment. And there are some pretty good tools that creditors have in order to collect the judgment. Things like a hearing on assets, wage garnishment, bank garnishment, things like that, right? Now, I talked about foreclosures. I'm not going to spend a lot of time on this. Really, the big question with a plaintiff foreclosure, meaning the association is the one who is initiating the action. You have to determine what the priority is and whether the association has a high likelihood of recovering all of the costs that are going to be spent in the foreclosure. So, several $1,000s definitely in costs. That's service of process, publication, sheriff's execution fees, appraisals, those kinds of things. This is also why your association wants to make sure that your registered agent information is up to date, and whoever is your registered agent understands what happens when they are served with a petition and summons on a foreclosure. What happens shouldn't be that manager or that registered agent pitches it in the trash or sits on it for 2 weeks and then sends it to the board, or sends it to the board and says, here's some mail we got. And then also what they definitely shouldn't do is give you legal advice and say, well, this is a foreclosure, you won't see any money, so you might as well ignore it. When an association is sued with a foreclosure, this is a really good opportunity for the association to get paid on a lawsuit and not have to bear the primary costs. So we won't go into the ins and outs of this and what But the takeaway is make sure your registered agent information is up to date, whether it's the association itself, whether it's a board member, whether it's an attorney or a manager. It doesn't matter who the registered agent is, apart from the other caveats that I said. Your registered agent needs to understand what it means to be a registered agent, other than simply collecting a fee from you on an annual basis and then not providing any service for it. So we like lender-led foreclosures, not because we like people's homes going into foreclosure, but if there is going to be a foreclosure, our clients tend to have a very inexpensive lawsuit, whereas they would otherwise hire us for a small claims or do a lien or something like that. So let's talk a little bit more about bankruptcy. So the bankruptcy code is very complicated, but the takeaway is, and I've already stated this, the automatic stay that goes into place when an individual files for bankruptcy, it's an iron curtain. It's absolute. You don't get to send demand letters. You don't get to run out and file a lien real quick. You don't get to file a lawsuit or anything like that. There are procedures that you must follow in order to lift the automatic stay and proceed. Just because there's a bankruptcy doesn't mean that the association's not going to see any money. And in fact, there's a misconception. In fact, a number of bankruptcy attorneys that we come across also have this misconception that if the association has sued and collected fines, assessments, attorney's fees, costs like that, the fact that it's reduced to a judgment doesn't somehow convert the nature of that debt or that obligation to something that can be discharged in bankruptcy. Sometimes bankruptcy lawyers think, well, unless it fits in these categories, it'll get discharged. Well, surprise, HOA debt fits in one of those categories. It is non-dischargeable. The individual might be able to fight it for a little while, but eventually it's going to get in front of the bankruptcy judge, and the law will be applied, and the debt not discharged. So if a person, say, files bankruptcy to try to avoid foreclosure of the association's lien or even a judgment lien on a house, eventually the automatic stay can be lifted and a determination of non-dischargeability made, and the bankruptcy proceed. So bankruptcy is conducted in federal court, that unlike small claims court, which is done in state court. Let's see, question, if a home in the HOA is foreclosed on, should I send the HOA dues to the bank of record? So this is a timing question. The word foreclosure refers to the right to redeem the property being foreclosed, which happens right up until the day that a judge confirms sheriff sale. So a property can go through foreclosure. There can be a judgment entered. The property can go to sale, and then a motion to confirm the sale is filed. But prior to confirmation, the individual can redeem the property, and all of the foreclosure proceedings get unwound. So when you send the dues notice to the owner, whether it's a bank who's foreclosed or someone who's bought it at sheriff's sale, it's after the date of the confirmation hearing. So where does the registered agent register? Registered agent is done at the Secretary of State. So when a corporation is created, there will be a designation of who the registered agent is. So for example, if we went to the Secretary of State's website right now and we used my Happy Acres HOA Inc., we would type in the business search Happy Acres HOA. It would bring up the record showing that it's been incorporated. We could click on it and it would tell us who the registered agent is and their address. So that would be the quickest way to determine who the registered agent is. And then if you're satisfied with that information, it's up to date, they're the person or the entity. So an entity can serve as a registered agent as well. Then if you're satisfied that you want to keep it, well, then nothing happens. If you want to change it, there is a change of registered agent form and procedure at the Secretary of State's office. And I'm pretty sure you can do all of that online these days. Okay, so we talked about different assessments. We talked about the methods of collection and bankruptcy, foreclosure. So we've wrapped that up. Feel free to ask more questions if you've got them. But now we're going to get into the structural and use restriction enforcement. And I have some entertaining and informative pictures for you. So this is bulk pickup day, day 261. This is bulk pickup day in Oklahoma City and just stays there forever. This is an actual case. I think illegal substances were involved with this gentleman, and he decided to paint his house. I'm not sure what the theme is, but I think he painted his face along with it. This is a house in Houston that the neighbors woke up, realized, oh, we don't have a covenant that says you can't paint your house pink and have all kinds of yard art on the driveway. And as I understand it, that was not a garage sale. That was their yard art. This is a case that we had in, can't remember if it was Tulsa County or one of the surrounding counties, but this was a case where a manager contacted us and said, hey, we have an issue we want you to take a look at. And this association had received an opinion from a lawyer that told them they had the ability to assess monetary penalties based on just rulemaking. The board decides, you know what, we're going to adopt a rule that says you can or can't do this. And if you don't do it, then we're going to fine you. And so they tried that with a doctor that owned a home, lived in a home in the neighborhood. And the doctor actually read his covenants and understood, wait a second, it sounds like you're just making this up. So in protest, the doctor found this toilet planter, and it's one of my favorite pictures. My career will end, and this will still remain one of my favorite pictures because it's such a poignant screw you to the homeowners association, who admittedly was stepping outside their authority. And we were able to, the doctor had an attorney that we work really well with. And so we were able to de-escalate everyone, all of the parties working well with one another. And I like this story because one, it's one of attorneys working well with other attorneys and not just rushing clients into court. Two, it took a lot of civility and humility on both parties' parts. The doctor, because he was right, and not to throw it in the face of the board, and the board to say, look, guys, we relied on advice. We moved forward on that advice. We're going to take a step back and let's get this resolved. And they did. The fines got waived. The toilet planter disappeared. And I have not heard another word out of this association as far as this goes. So let's see. Okay, so yeah, Neighborhood Alliance posted a link to the Secretary of State's website. That's great. And then a bit of Tuesday discussion. Where do I file amended HOA bylaws? Does it need to be notarized with the HOA seal? I'm assuming your homeowner association, not condominium. if you want to file amended HOA bylaws, you would file them in the county clerk's office. Now, some legalese or some technicalities here. It does have to be notarized. In other words, there must be a notary seal on it, but it has to be acknowledged. So if you look at the end of a deed or a mortgage where there's a block of language where the individual signs, and then below that is another block of language, or a block of language where the notary signs, that's called an acknowledgement. In order to record something in a county clerk's office, it has to be acknowledged. So yes, your bylaws do have to be notarized, and then it also has to have a legal description. Otherwise, it's just going to be floating out there in limbo, and no one will know that it's tied to your neighborhood. So there are some components that you want to make sure you get right for the bylaws. One, just so that it will be accepted for filing, and two, so that everyone in the world knows and can find the fact that these bylaws are tied to the real property for your neighborhood. Next question, what if we want to change the name of our HOA? This can be really tricky. So this is why we look for strategies to do things like correction deeds or trade name reports. What we're trying to avoid is going into the covenants and having to amend the covenants just to change the name of the association. And that's solely because there is some typically heavy lifting going into amending covenants. We're going to talk about amendment, and I'm watching the clock. I'm not going to miss it. We're going to talk about amendments, but covenant amendments are tricky sometimes. They are almost always labor intensive. So to answer your question, it really just depends. It can depend on, do we need to change the name in the covenants? If so, then it takes a covenant amendment. Do we need to change the name at the Secretary of State's office? If so, then we need to file amended articles of incorporation. If we just have an extraneous deed, or if there's something wonky on a plat, or if everything is fine except for maybe this one little thing, well, then maybe we do the trade name report trick and not go through all of the heavy lifting of amending covenants, or even filing trade name reports, or excuse me, changing the name of the association. So, okay, so let's talk about judicial enforcement, the traditional remedy for enforcing covenants. And that's whether it's a use restriction like running a saloon or a barbershop out of your garage, short-term rental violations, those kinds of things, or if it's a structural restriction. You built the Taj Mahal of sheds in your backyard and it needs to be torn down. Those traditional remedies have to be brought in district court. You cannot get injunctive relief in small claims court. Small claims court is a court of limited jurisdiction. Only certain claims can be brought, and claims under $10,000. So if the issue deals with enforcement, then you're probably looking at district court. Sometimes we can bring an action in small claims court that might kind of skirt the line. So there's something called replevin. If you ever watched the Coen brothers remake of True Grit, when the young lady is in the horse salesman or the stable office, and she says she's going to sue for replevin, this is what she's talking about. When someone has something of yours and you want the court to make them give it back, you can sue in replevin. Replevin is one of those actions you can bring in Oklahoma small claims. Well, that certainly doesn't fit under the umbrella of make someone do something or make someone stop doing something when it comes to operating a business. They don't have something of yours that you want the court to order them back. Typically where this will come in is if someone has taken something from the association Oftentimes, this is a books and records or checkbook, or someone has the passcodes to the website, or oftentimes when a manager or treasurer or bookkeeper or board member leaves and they feel like, well, this is mine, I worked on this, so I'm going to take it. If we can't convince them, hey, look, the fact that you created it doesn't mean it's yours, you did it as a board member or as a manager, you have to give it back, then maybe we could bring that replevant action in small claims court. So this is a very broad breakdown of judicial remedies. One of the main things that we want to look for before we go into court, apart from board members who are willing to spend the time involved in litigation. Again, you're going to be spending time with lawyers, not necessarily the funnest folks to spend your time with. Your association is going to be spending money on those lawyers. Most associations don't have really deep litigation budgets. One of the main things that we want to look at is, okay, is there a pathway to having attorney's fees awarded? And that pathway is either by statute or by contract. Fortunately, most of the time in HOA enforcement cases, we have both. Both in the being the contract, the covenants, providing for prevailing party attorney's fees, and then also in statute. Okay, so the comment is we want to move away from the word plantation in our neighborhood. So that's going to be tricky, if certainly understandable, but tricky from putting into effect. So if the plats, plat or plats, use the word plantation, that is going to be exceptionally difficult to change those plats. And this would be in the cost prohibitive category. You could do it. We have a statute that basically wipes race covenants off the county clerk's records. Now, this is interesting to me. I don't think I have seen that statute, and this is a nationwide deal. This is the statute that the legislature adopted. It's kind of uniform language. It's been adopted in many states. I'm not aware of that ever being used on a plat, though, to take away a word like plantation. So that's interesting, and that's one of the reasons why I love these conversations. Is I learned something, it sparks new things to think about, and so I will be going down a research rabbit hole on this. So getting back to answering your question, it would be very difficult to take that word off the plat. It would take a covenant amendment to take it out of the covenants, but whether you're taking that word or changing, the HOA to POA or whatever, you could certainly do that. And the Secretary of State's going to be the easiest. Boards can unilaterally amend articles of incorporation. Boards can amend bylaws. It's the covenants that requires input from the lot owners, and the plat includes not only input from the lot owners, but probably, and I say probably, meaning you would have to get the city or county's approval for amending the plat. So some heavy lifting on the plat and covenant side, pretty easy on the corporate side.
I just pulled their plat, and you'd mentioned, the race-based portion on the federal side. I didn't know if there was almost like a trigger date that started that before or after, but it looks like they were platted in the 2010s, and I didn't know if that would be a problem.
No, I don't think. I have to refresh my memory. And this is an interesting. No, I won't go down the rabbit trail. Oklahoma has an interesting history with these race covenants. You come across them in neighborhoods, and historically we simply ignore them. And but in terms of how to actually go in and functionally remove them from plats, I'm not aware um, of anyone that's done that. So I don't have any experience in it. And usually, again, it's a money issue. Is the association wanting to spend $3, $4, $5,000 to amend their plats, to go through the planning and the zoning process again in order to remove that word? Um, Possibly. There's another comment. Okay, that's just a thank you. All right, so once again, I want to leave the enforcement discussion with this picture, because I get caught with this all the time, and it embarrasses me and it shames me. And you would think I would be a better learner, um, that I jump to the conclusion and the assumption, and this is why boards. I want to talk just a second about how important it is to have a diverse board. And when I say diverse, I'm not just talking about uh, gender, backgrounds, color, anything like that. I'm also talking about how people view the world, how people view others. The more diverse personalities and the way people think uh, that you can have on your board, the better functioning the board could be. I'll say could be, should be. Sometimes people think, well, we all need to think alike, and then we can really get something done. That is not how reality works. The reality of a great board is one who all they have to do is agree on one thing, and that's board unity. That we are going to disagree. That's par for the course. We're going to have differences of opinion, sometimes very fundamentally, and sometimes we may even actually have to take a vote. And built into the system is someone's going to get outvoted. But that's reality. That's how this works. And what we have to be committed to is, no matter if I get outvoted 9 times out of 10, I'm going to be committed to the unity of the board, which means I'm not going to go on social media and just start, tearing people down. And, well, I don't know what the board's thinking, but you all need to know I didn't vote for this. And part of that, being open, letting down a little, maybe some defensiveness, is continuing to reinforce, to demonstrate honesty, supportiveness, I've got your back, unity among the board. Those communities where board members do that really well, those communities pay less attorney's fees. They have higher senses of community. I would say there also tend to be communities that work a lot with Neighborhood Alliance and who attend a lot of their workshops. I've worked with Neighborhood Alliance for 20 something years now, and I wouldn't do that. I would not commit 4 hours out of my week this week to donate time to spend with Neighborhood Alliance if I didn't believe in their cause and feel that sense of unity with them. So they practice what they preach, and you can certainly learn how that works and what that looks like from Neighborhood Alliance. But one of the things that I want to say, and then I'll move on, I'll get off my soapbox, is, when I jump to the first picture, if it's just me, the likelihood that I get moved off of that assumption, or that I move from the first picture to the second, the percentage is very small if it's just me. Because well, I'm right. I'm thinking. I have rationalized this. I have my reasonings. But when I have someone in an environment that I trust or that I can hear certainly has a relationship with me that says, okay, look, I get it. You think it's picture number one, but man, let just listen for a minute and let me show you how it's picture number two. The percentage chance that I can get to picture number two is the percentages aren't even close. I'm much more likely, and I can recognize like, all right, this is one of those instances. I jumped to a conclusion. Thank you so much, and that in and of itself reinforces that unity. That's how great boards work. It's how every great relationship actually works, where you have that. All right. So we're going to move on to amendments. I want to talk a little bit about this. I'll just let you read this. And this is actual amendment language from an Oklahoma County neighborhood. This language is so terrible for multiple reasons. The fact that it had to underline, and by the way, I reproduced this verbatim. This is exactly how it appears in the real property records. I did not embellish this at all. Didn't have to. So the fact that someone felt compelled to underline the open parenthetical that just never closes, the punctuation's terrible, the grammar is terrible, the ambiguity, there are multiple ambiguities. You have no idea what this is trying to do. I can tell you what it's trying to do. It's trying to establish a hunter's ethic. There's this idea when it talks about cripples, it's talking about wounded birds, typically waterfowl. Well, there's this idea that it's unethical to shoot birds unless they're flying in the air. You got to blast them out of the sky as opposed to blasting them on the water. That's the waterfowl ethic. And so this covenant, it's a kind of a sports community. They have a lake and all that, and that's what this is trying to do. So I like having this, showing this, so that you can see one of the major reasons for amending covenant language is it's just really bad language. It doesn't do what it's intended to do. It's ambiguous, and when something is ambiguous, what happens in court is you have all of these different contractual interpretation standards that come into play. And one of those is, well, can we figure out what this clause means from the four corners of the document? Meaning, if we read it from top to bottom, can we understand its meaning? And if we can't, well, then we have this standard that says, well, let's go to the drafter. Let's see what was in their mind and get their intent. Well, maybe they're dead and gone, or maybe we can't get them, and maybe we don't want their intent. So if we have ambiguities that we're dealing with, if we just have flat out bad language that a developer or a builder or prior owner has saddled us with, well, then let's change it. Met with a client today, and one of the issues is there's this weathered wood only shingle restriction, which is, you talk about ubiquitous, and there might be other shades of roof shingle that the lot owners want. Well, sometimes board members feel like, well, it says this thing, and so therefore we have to stick with that. And maybe you don't want to stick with that. Maybe you want to change it. So there's all different kind of reasons. Maybe there's obsolete language. There's always going to be, particularly if I drafted the covenants, there's going to be a lot of developer or declarant language in there that at some point it's defunct. When we file the covenants for developer clients, we want to preserve all of these rights so that they have the flexibility to do what they need or want to do in the development. But if everything goes right, then that developer won't be there after a while. Well, all that language can go away. By the way, I see this all the time where neighborhoods or boards or neighborhoods themselves think, the lot owners in a neighborhood think, well, once the developer declarant's gone, the association succeeds to all of those rights. Not true. Not it doesn't happen under the law. It doesn't happen by just this general, well, developer was there, now it's the association. It either has to happen by the language of the covenants, or there has to be some kind of assignment, or the covenants are amended to put those rights in the association. So it doesn't happen automatically. The important thing when it comes to covenant amendment projects is to remember covenants are not bylaws, and covenants and bylaws by the law, by the terms of statute, and oftentimes by the terms of the documents themselves, are amended differently. So this is gross generalities speaking when it comes to covenants, because it is possible to have a covenant that can be amended by what's like a corporate vote, electronic proxy, non-notarized ballots. It is possible, but most of the time, if we're talking about amending covenants, they have to be amended with a notarized ballot, and that ballot must be signed by each person who owns a lot if you want to count that lot's vote. So what I'm saying is, if two spouses own a lot, both of those spouses must sign a notarized ballot in order to count that ballot. All right. One spouse cannot sign for the other spouse any more than one spouse under the law can execute a deed on behalf of the other spouse. You can do that, but it takes a power of attorney, and that power of attorney must be filed with whatever that real estate instrument is, whether it's a deed or this notarized ballot. So there is a significant formality that goes along with covenant amendment projects. Strongly recommend that an attorney who is familiar with completed covenant amendment projects assist. At least on the back end, before you take your vote, before you file it and have to undo it, speak with someone who's been down this road before. Bylaws, easiest thing in the world to amend if we're talking about a homeowners association, because, and I cite this in that bottom bullet, 18 OS 1013, and I did mention this in part 1, bylaws can be unilaterally amended by the board itself. Now, it may not be a great political decision, because if a board wakes up and decides, you know what, all of those due process rights and the bylaws, we need to get rid of those. All of that good notice language, let's get rid of it. Hopefully, someone in the neighborhood is paying attention, gets really angry, and throws that board out and puts one in who will afford them due process, because that's what we're all entitled to under federal and state constitutions. It kind of makes sense that it's afforded our HOA members in the bylaws. So sometimes we might want to submit bylaw amendments to the membership, not because you have to, just call it political cover, call it. It's something that the board feels strongly enough. So for example, say the bylaws don't say anything about sales of common area. That's typically a extra, or what's considered or called an extraordinary corporate event, when the corporation is selling or transferring common area. Well, this comes up sometimes when maybe you've got a green belt, there's some houses that back up to the green belt, the association pays thousands of dollars a year to maintain it. It's not drainage or detention, it's just this unbuildable land that the association's been saddled with. Maybe it makes sense for the association to sell it and get rid of it. But if the bylaws don't provide a mechanism, or maybe the bylaws provide too difficult a mechanism, say the bylaws require 90% of the membership to approve, but it only takes a simple majority to amend the bylaws, then why not submit it and get that changed if that's something that the the majority of the neighborhood is in favor of. That might be something that a board would submit to the membership vote. All right, question. In order to amend covenants, do 100% of eligible voters have to do this, or only the majority as specified in the covenants? So when it comes to covenant amendments, we're not talking about a member in good standing. We're not talking about people who have paid their dues. You could have the worst covenant violator in the neighborhood, and they still have the right to vote for or against a covenant amendment. Of course, they're not going to vote for anything. They're not going to vote at all. It's not eligible voters. It is everyone. And what percentage is required? That is a legal opinion. And it is a legal opinion that is formed based on reviewing the covenants and also Oklahoma law. So when looking at this slide, if you look at the second to the last bullet, there is, well, look at the third bullet. So the third bullet references 11 OS 42-106.1. That is a state statute that says if your covenants have been on file for at least 10 years, then you can amend with a 70%. If they've been on file for 15 years, then that goes to 60%. Now, it's important to pay attention. That law applies, that law and the percentage in that law applies to the number of platted lots, not lot owners. And so you have to do a lot count, and you also have to see how long the covenants have been recorded for. You also have to determine which covenants are we talking about, if there's multiple sets and if those covenants have been amended. So this is why it takes a legal opinion. And then second, you have to look at the language in the covenant itself to see, does it provide for simple majority? Does it provide for supermajority? Is that percentage based on lot owners? Is that percentage based on platted lots? And then two, there is some old, you still see it every now and then, language that talks about these covenants shall, I'm paraphrasing this covenant clause, amendment clause that we see occasionally that you have to be careful with. It goes, these covenants shall run with the land and be binding on all owners from, say, January 1, 1990, and shall extend for 20 years, at which time they will automatically extend for another 10-year periods unless otherwise amended. So if you have an amendment clause like that, you don't have a simple majority amendment percentage. You have two percentages. One percentage is 100%. So during that first 20-year period, it's 100% in order to amend those covenants, which is impossible unless they're all owned by the same person. That's why the developer is the one who files the covenants, because it's all one person. So that is called a restrictive period. On January 1st, 2010, which is the first expiration, well, that is the only expiration, that's the 20-year expiration, that on that day, you get your simple majority. Problem is January 1st, 2010, or January 1st of any date at any time, the county clerk's office is going to be closed. So you can't file it that day. I guess you could take your amendment vote on that day, but you're going to have to wait till the second or the third or whatever the next business day is to file that amendment. But as soon as that date rolls over to the next day, you're back to the 100% for your 10-year periods. So, and we actually have a reported court case on this. The law is abundantly clear in Oklahoma. If you have that at which time language that isn't otherwise modified somehow by the amendment clause, you have those restrictive periods. So it could be 100%, could be simple majority, could be 70% based on statute, could be 60%. It takes research and forming an opinion on how to do it. So if after all of that you're thinking, good grief, notarized ballots, 100% lot owners versus plat. This is impossible. It's never going to happen. The good news is it happens all the time. We have any number of these amendment projects running at a given time throughout the year. There are things that you can do to maximize the chances. There are also simply some circumstances where you're just not going to get the covenant amendment that you need or think you need or that you want. So, for example, if you have a neighborhood of, say, 100 units, 100 lots, and 55 of those lots are landlord owned, the idea that you could get a no leasing restriction passed, we wouldn't even take that file. It's just not going to pass. Now, what could possibly pass is a form of leasing restriction that would possibly be attractive to some landlords who understand economics and cornering markets. We might be able to draft a leasing restriction that would get them excited. So it kind of depends on what your goals are, what the composition, owner versus tenant ratio is in the neighborhood, and how your covenants are drafted. So a lot of times what we'll do is we'll have a drafting committee. We will have that committee test the waters or do surveys, have information meetings, put it out on social media. If we get the sense that an amendment conversation has only been going on among a couple of board members, we're going to strongly suggest that the conversation be expanded to the neighborhood. If it's a large neighborhood, then getting block captains appointed. We look at collection percentages, the idea that a neighborhood who has only 60, maybe 70% of the neighbors paying their assessments on time and in the right amount, that they could hit a high percentage for a notarized ballot. What we have found is that that's not going to happen. If you have a pretty poor collections percentage, then that's a really good indication you're not ready for an amendment project. If you're hitting 90%, 95%, what that shows is a pretty high level of customer satisfaction, or enough ambivalence that at least they will cut a check to be left alone. We'll take that too. So we all know that ambivalence runs pretty high in homeowners associations, reflected by the number of people who volunteer to serve on the board and show up at the annual meeting. And that is why in almost all of these projects, these covenant amendment projects, you have to be willing to go door to door collecting notarized ballots. So if you're not willing, or if you don't have that that infrastructure, so to speak, those people ready to go door to door and spend several weekends, beating the pavement and collecting notarized ballots, well, then it's probably not going to be a successful project. Now, if you are small, say 30 units or less, gated community, or even a public street community, but it's a small number of units, what we find is those require less organization. Those neighborhoods tend to have more communication, more cohesiveness. Everybody knows each other. And so those can often get away with just calling a cul-de-sac party. I've had voting meetings with folding chairs in the middle of a cul-de-sac on a beautiful evening, and they get their vote. I've had others that are conducted in the living room of somebody's house, and people come and go, and it's more of a social thing. And so those, it just kind of depends on the composition of your neighborhood and what kind of covenant language you're looking at. All right. May seem like an obvious question. Does your practice offer a review, assessment of current covenants, bylaws, and advise board of best practice future goals? Of course, for fee, hard question to answer, but what does that cost look like? What I would say is, yes, yeah, that's all my firm does is HOA law, both transactional work and litigation. And part of the transactional work would be working with boards on identifying, better strategies for administering the covenants you have, or assisting with modifying covenant or bylaw language. What I will tell you though, and I've been doing this long enough and closely enough with Neighborhood Alliance, and this isn't just um, sheer pandering to the people that host this, um, but the more your association can get away with doing for free, the better. I am happy to work with associations. It's what I do. But if you can get the project, whatever that project is, whether it's an enforcement project, whether it's a collections project, amendment project, or hey, we need some help figuring out how to deal with this person that is destroying our community on social media. I mean, we handle all of that. Or, hey, how can we be a better board? How can we have better board meetings? What I would suggest is that you start with Neighborhood Alliance's resources, and then from there, take what you learn, and even if what you're learning is how to ask better questions, different questions, or at least be more in tune with, okay, this is what we're dealing with. This now we have a better idea of this is where we need to go, and then schedule time with an attorney. If it's kind of like plumbers and any professional, mechanics. If you take your car to a mechanic and it's like, I think something's wrong, I want you to look at it. They are going to find something wrong and they're going to charge you for it. Not necessarily that's what attorneys do, but if you can bring me, it's the difference between bringing me a set of covenants and saying, hey, I want you to take a look at these and tell me everything that's wrong with them. I will definitely tell you what's wrong with them. I can certainly do that. And I can take all day doing that if that's what's necessary. Or if you come to me and say, hey, look, we're having a problem with people leaving trash cans out, parking in the street, dogs running loose. If you give me some ideas more of the issues that you're dealing with, well, now I can go to your covenants and I'm gonna be thinking, okay, number one, what does their enforcement clause look like? Number two, do they have a monetary penalties, individual assessments? Number three, forget the covenants. What does this neighborhood look like in terms of its cohesiveness? This gets back to, okay, we can have the best covenant language in the world. I could draft you the gold standard for enforcement. But if you have to use it in every single instance, you're going to be paying attorney's fees way too much, way too often. So sometimes the approach isn't necessarily, well, let's get better covenant language that we can enforce. Sometimes it's, well, maybe you can enforce the language that you have now, but what are we doing to perhaps encourage people to follow the covenants that are in place? And if we have to amend the language, what tells us that we could convince these people to vote for it in any event? So, yeah, I'm happy to do that. But the also on covenant amendment projects, it's much better for the board or the drafting committee to have gone through, not necessarily, you know, picked over it with a fine tooth comb, but at least have an issues list. Okay, here's the 3 to 5 things that we think we want to fix with the covenants, and then bring that to me. Sometimes you know exactly. We have an Airbnb event party house. It's driving us crazy. We need to know how to fix that. And I can rifle shot that. We've been doing that for several years now and have had great success both in court and amending covenants to address that. Let's see. I covered everything on this. One thing to consider too. So with the ballot, when we're amending covenants, the only thing that matters is, did you get an acknowledgement from 100% of the lot's owner or owners? People who want to vote no for the covenant amendment proposal, they don't vote at all. I have had projects where people were going nuts in that they didn't have the opportunity to vote no. But that, in my world, that's the equivalent of me going crazy that I don't have the opportunity to sign something in front of a notary that says, no, Bank of Oklahoma, I will not give you a mortgage on my property. Or, hey, you random stranger, I am not going to deed you my property. I mean, the only time you execute a deed or a mortgage or a ballot for a covenant amendment is in the affirmative. So if we, I guess if you scream at me, I will draft a ballot that says check yes, check no, but it's really only, are you in favor of it? But beyond that, the question is, well, do you do an all or nothing? And what I mean by that is sometimes you can have interrelated amendment proposals. So for example, if you want to consolidate all of the 4 or 5 different sets of covenants, if you want to take out the declarant language, if you want to fix some defined terms, you really, it's very difficult with one of those projects to do a line item ballot. And in a certain sense, it doesn't make any sense to do it that way. Others, if say you want to ban backyard chickens, you want to put some kind of restriction on leasing, you want to adopt a fine schedule. Well, those are not interrelated. You could do a line item. And if you think, okay, I know we have the votes for backyard chickens. Everybody wants backyard chickens, but we're getting a lot of pushback on this fines thing. Fines are kind of hard to sell sometimes. It's helpful if you can if you can communicate clearly what the purpose and how they work, but getting over the, well, I'm not comfortable with the idea that the board has the ability to fine. I get that, but you've also elected this board to spend every single dime of the association's money in attorney's fees in court. You've already handed over the reins. So a lot of times it just takes a little bit of communication on, okay, let's look at the reality of the authority of the board. And by the way, if you ever have a board that's run amok with fines, then you yank them and you put someone in who isn't. By the way, I don't ever see that in our office where boards have just gone nuts and are adopting fines willy-nilly. I'm sure it's out there somewhere. You can certainly find the horror stories on the internet. We just don't see that in our office. What we see are volunteer board members who are not getting paid, who are taking time out of their jobs, their families, their vacation or their retirement in order to serve their neighborhoods. The last thing they want to do is prowl the neighborhood and start finding people. So all right. So let's talk a little bit about insurance. So I'm not going to go into detail on condo insurance other than there are a handful of really good condo insurance brokers, agents in the Oklahoma City, Tulsa, various areas. I would seek them out if you have a condo, because if you have a condominium association and what you find is a CGL or a commercial general liability policy placed for your association, it's the wrong product. Someone didn't know what they were looking at or what your association needed. But even beyond that, having someone, and this is where a really good manager helps. A manager who has managed condos, who possibly is a real estate broker or real estate agent, someone who understands real estate and who has been trained and is licensed to do it, understands what a condo blanket policy is, an all-in policy, a bare bones policy, what the meaning of studs out means, and what an HO6 covers, doesn't cover, and what loss assessment is. Those are all very important things to know and understand in order to place a condo policy. So much easier to place a homeowners association policy. You want property coverage. What does the association have that an F5 tornado will rip off the face of the earth that we want to have an insurance company pay to replace? What kind of liability does the association have? Do you have a pond? Do you have private streets? Do you have a gate? Do you have a clubhouse? And then also having a directors and officers either endorsement or a standalone policy. And you have to make sure, whether it's condo or homeowner association, if there are provisions in the governing document that say thou shall have XYZ insurance, you got to place it. And because, again, like we talked about, going through and highlighting the shalls, if there's any, you shall have this type of insurance, then you want to make sure to discharge that. So I'll mention this now too, because I do this in my covenants, and it's an exception to what I've been stressing about shall. So in my covenants that I do for developers, there'll be language that says the board of the association shall place, to the extent available and subject to the business judgment of the association. So this is a lot of those lawyer weasel words. So what I've done is I have packed that sentence initially with a shall, which we know is a non-delegable mandatory thing, but then I have watered down that shall several times. One, it's the policy that you shall place, it's got to be available. So if if there's language that says they shall place a policy with a $5,000 deductible, well, what if there's not a $5,000 deductible policy available? Now you've put the board in the situation where you have mandated something that is impossible, a futile act. Well, we don't want to put boards in that situation. So I further water down the shall and subject to the business judgment of the board. So now I've qualified that shall with, okay, you got to be able to find it, number one. And two, you can exercise business judgment. And so if the board goes into the marketplace and says, wait a second, if we were to place the policy that the governing documents say it is going to put us into insolvency, we're not going to do that. We're going to come up with what we feel based on our insurance broker or insurance agent's input, reliance on professionals. That's what we're going to do. Well, then that is business judgment. And under 18 OS 1027E, the board is given this statutory immunity. All right. So I think it's important to stress that, because I do that myself with my drafting, is I want to set up this hard standard, this hard and fast standard, this duty, but then I don't want to make it so rigid that it breaks the bank or it breaks the board. All right. So one of the reasons, the main reasons why we have insurance is not so that there will be coverage. Obviously, we do want the coverage. We don't want to just throw premium money down the toilet. But one of the main things that we're looking for, particularly on liability, directors and officers, and general liability, is a duty to defend. There are, lawyers are a dime a dozen out there. Our law schools keep cranking them out. They keep passing the bar, and there is a client to fit them. So the way our legal system is set up, it necessarily has to be this way. The funnel to get into court is very, very wide. All right. And then it narrows from there. So it's very easy to file a lawsuit and to get into court. Now, where it goes from there really depends. People threaten, I'm going to, sue you, board, if you don't replace the tree in the common area behind me. Those are empty threats. Don't have to even acknowledge those. But when a lawsuit is filed, you cannot ignore that. I mean, you can, but bad things happen when you ignore it. So what you want to do, if the association is named in a lawsuit, or if individual board members are named in a lawsuit for things within the scope or realm of their duties as a board member, then you need to notify your insurer immediately. Maybe they deny the claim, and then maybe you talk to a bad faith lawyer for whether there's a claim against the insurance company for denying your claim. But a lot of association insurers will enter an appearance in the lawsuit. They will provide the cost of defense, but they'll do it under what's called a reservation of rights. And that's mainly what we're looking for, is at least an entry of appearance and the insurance company paying for your lawyer. So that's one of the best benefits of having insurance. All right. While we're talking about insurance, this naturally leads into other liability discussion. And this may seem kind of odd, but several years ago, we were able, and I say we lobbied the legislature, my firm did, to modify a law that had been in existence for a long time, favoring tax-exempt nonprofits in Oklahoma. And the law said, and it's referenced here, Title 18, Section 865, 866, and 867. And this, prior to the law being changed or expanded, it only applied to tax-exempt 501c3 entities. Well, none of my association clients are 501c anything. They're not tax-exempt entities. However, there is an exemption that residential, condo, and homeowners associations do fall under, and that's Section 528 of the Internal Revenue Code. And so what we asked the legislature to do was, hey, look, we want to encourage people to serve on these boards. And so will you change the law, expand it just a little bit to include any entity that files under Section 528? Legislature was like, sure, why not? So they did it. Well, 528 is the annual election that residential, condo, and homeowners associations make under this Form 1120H. So the takeaway is, and you can go to Title 18, Section 865, 866, 867, you're going to read the language, but basically what this law does, if your association files, that's 1120H on an annual basis, you're probably not going to pay taxes unless you have a really big reserve fund. It just dawned on me, I skipped over the reserve fund portion of the financial the financial pie. I'll cover that in just a second. Sorry about that. So if you have a really large reserve fund and you're getting more than $100 in interest income, or if you sell ad space, some associations will have a newsletter, or online they'll sell ad space, or if you have any kind of unrelated business income, swim team fees, clubhouse rentals, things like that, you might pay a little bit of income tax on a Form 1120H. But the benefit is you get all of this good limited liability, meaning you're not, you individual board members and the association, you're not going to be responsible for simple negligence. So simple negligence is, innocent rear end car accident, or simple negligence is, the gates accidentally close on somebody. Then you might possibly be responsible for the property damage, but there's not going to be this simple negligence standard. Usually where this bears out is, board, you made a mistake, you got something wrong, therefore you were negligent. You were negligent in the maintenance of the common area and it's decreased my property values or something along those lines. That's not available under this immunity, and it goes to gross negligence. Gross negligence is any kind of intentional wrongdoing. The treasurer stole the money out of the association's bank account and went on a vacation with it. That's gross negligence. That's an intentional misconduct. Or negligence that rises to the level that you should have known, you did know, you were reckless, something along those lines, where it's not just a simple mistake or an accident. This is something that you ask 9 out of 10, possibly 10 out of 10 people, and they will say, yeah, you can't do that. So that's basically what gross negligence is. Also, what this statute does is it gets rid of joint and several liability. What that means is we're going to hold one board member responsible for other board members' wrongdoing. Under this statute, you're only held for your own wrongdoing. Now, something to think about is, it is considered a breach of duty, or can be considered a breach of fiduciary duty, if the treasurer is stealing the money and the other board members have turned a blind eye, or with just basic business practices should have caught them. Well, then they could be liable for their own wrongdoing or their own gross negligence. So one of the best ways to mitigate against both embezzlement and someone saying, well, you breached your fiduciary duty, is having regular board meetings, having reconciled bank statements, and understanding what you're looking for in bank statements and those reconciliations. So if someone does a cash check to themselves, or they loot the bank account and then skip town, and no one had an opportunity to do it, it's kind of like, well, you can't hold the bank teller or the bank managers responsible for someone that breaks into the middle of the bank and robs the place. You can hold them responsible if they leave the front door open and all the tills open. Well, that is something that they have done wrong. But if somebody uses brute force, or if somebody steals the association's money before the board could catch them, well, then there's no breach there as far as the board members go. You hear this the term fiduciary duty thrown around. I see it in emails thrown at boards, that there's this idea that if you do anything that someone doesn't like, you have breached your fiduciary duty. Or if you make a decision that they think is wrong, you've breached your duty. That is not what fiduciary duty is. There are only a couple of fiduciary duties, and one of them is the duty of loyalty. As a board member, you have a duty of loyalty to the corporation. That is who your loyalty flows to, not individuals, not the individual members. It's to the corporation. Now, the individual members are beneficiaries, but it flows to the corporation. You also have a duty of good faith or intentionality, and that's, are you operating as an honest, good faith board member or officer should? And then you have to avoid improper personal benefit. Where this happens is, oftentimes, say I'm president of an association. I have a child with a landscaping company. They have uh, an ability to provide not only better services, but at a rate cheaper than what the association's paying, them working for the association would be a benefit. And to avoid what appears to be an improper personal benefit, someone scratching my son's back or my daughter's back in their landscaping company in order to funnel that money to me, I can follow what's called a disinterested or an interested director's procedure. And that's, I can be at the meeting where the proposal is discussed. I can be counted for quorum purposes, but I cannot vote for it and I can't engage in the discussion. And in fact, ideally, what you should do is be counted for quorum purposes and then leave the room for the discussion. So it's okay to have family members do work for the association. We just have to avoid the improper personal benefit. So that's a rundown of fiduciary duty. What is the annual month to have the 1120 form submitted and to whom? So this is where I'm going to give you my another disclaimer. I am not a CPA. I will tell you my understanding with the caveat that this could be completely wrong. I believe you file the 1120H by March 15th, along with other corporate returns, and it's filed with the U.S. Treasury, so the IRS. It's 1120H is a federal form. It's based on Internal Revenue Code Section 528. Now, where things get murky is at the state level. There is not a corollary to Section 528, which is a federal statute. There's not a corollary in the state code. So this is where you definitely want to talk to a CPA and ask, okay, one, when do we file this 1120H and what do we file at the state level? And see what help you can get from the CPA. All right, talked about fiduciary duty. We talked about this. So I don't think I have gone into enough detail about the business judgment rule. I know I've mentioned it and you probably can get the idea if you're not already familiar with it, but the business judgment rule is a standard of law that a court is not going to second guess the judgment, the administration of a board. Otherwise, everyone would be taking claims to court and it'd be putting judges in the position of trying to decide, okay, how should the association be operated? Should they have picked this landscaper versus that landscaper? In order to avoid that, we have what's called the business judgment rule. And so what does that look like? Well, it looks like boards operating the way we think boards should operate. It's boards operating the way the governing documents require them to operate. Well, okay, great. What does that look like? It looks like boards meeting regularly, whether that's in person or by Zoom. It's immaterial one way or the other. Boards definitely, and we do have case law on this, definitely looking at the bank statements each month. I mentioned reconciled bank statements. This case did not talk about reconciled bank statements. It just talked about going to regular board meetings, but looking at bank statements, understanding what you're looking at, having reconciliations, not simply relying on created reports from treasurers. One of the worst embezzlement cases that I've seen in an HOA, and thankfully they're few and far between, but the worst ones that I've seen typically involve a treasurer who is a bit of a bully, an actual bully, and a board who is too scared, too disinterested, or can't be bothered with actually digging into, okay, wait a second, what you're telling me doesn't make sense. These numbers don't make sense. and not following up on suspicions. So treasurers who have nothing to hide, who aren't being unduly accused, are typically pretty open and not angry or aggressive. Now, if you're calling me names, if you're accusing me of theft, I might get a little hot under the collar and defensive. But most of the time, people who are good faith, they enjoy sunshine, they enjoy transparency, and they enjoy having other board members confirm their work. And yep, maybe they make a mistake every now and then. But again, we're in this environment where if I'm the treasurer and I have made a mistake, someone can say, "Hey, Matt, did you mean to move, $1,000 from our reserve fund to the general operating fund?" Oh my gosh, no. I'll fix that right now. So having a board environment where people again support one another, it also helps tamp down on the embezzlement. Okay, we're almost out of time. I'm going to correct my mistake and talk about reserve funds. The way I'm going to do that, because I think we are. Oh, we got a couple more minutes. So if you will go to www.cairf.org, and I think I've got that on that slide actually. I do. So on that slide after reserve, I've got CAIRF BPR for reserves. What that means is, and if you go to cairf.org, there's going to be a list in the upper right hand, or there'll be some boxes you can click. One of them is called Best Practices Report under their publications. There is a best practice report for reserves. Click on that. It's great information. It's put out by the Research Foundation for the National Trade Organization for Community Associations, called Community Associations Institute. And this best practices report deals with reserves. So basically, a reserve is a savings account. It's an intentional savings account, not just a slush fund that, oh, we had some money left over, we didn't spend all of our dues, so we'll just move it to this account. It may be that your association needs very little money in a reserve account. If you don't have any capital improvements, if you have a $5,000 deductible on your liability policy, public streets, no common areas, well then $5,000 reserve may be perfectly fine, or $10,000. If you're a condo association and you have a 1% deductible for wind and hail for your roof, and it's going to be $200,000 to access that, $5,000 reserve is going to be woefully insufficient. So go to your governing documents, see if a reserve is required. Think in terms of, okay, what do we have to replace if it wears out? What do we have to access in terms of insurance deductible? And then let's have that in the bank. So it's an intentional savings policy. There are folks out there that will perform a reserve study. Some managers will help you do that and are trained to do that. Understand the 5, 10, 15-year remaining useful life is something to familiarize yourself when it comes to reserve funds. So that is the bulk of what I wanted to cover. There are some more slides that will be included, although there won't be commentary on it. Thank you for spending a good portion of your time this week, 4 hours with us, and your questions and comments.